These are the jobs you may not see every day, but just know we're working hard to make Hillsborough County a better place to live, work, and play. Subscribe to our YouTube page for more great county-related videos, only on HTV.
Good morning and welcome to the October 23rd, 2023 Land Use Hearing Officer meeting. I'm Pamela Jo Hatley and I'll be serving as your Land Use Hearing Officer this morning. Before we get started, if you'll stand as you're able, please, for the Pledge of Allegiance. right, thank you. Again, I'm Pamela Jo Hatley, and I'll be serving as your land use hearing officer this morning. If you have any devices that make noise, would you please silence them at this time? And thank you for that. All right, I'll introduce Ms. Colleen Marshall, the Hillsborough County Development Services Department, and Ms. Marshall will introduce staff and any agenda changes.
Good morning. Colleen Marshall, Development Services. To my right is Carmen Mason of Development Services staff. To my left is Mary Dorman of the Hillsborough County Attorney's Office and Jillian Massey of Planning Commission staff. During the course of the hearing, a number of other planners will be presenting their findings for various cases and will be introduced for each item. We have a number of continuances and withdrawals today. Item A1, Special Use 230219. The applicant is Dean M. and Sonia C. Slavin. This application is out of order to be heard and being continued to the November 20th, 2023 Land Use Hearing Officer hearing. Item A2, Variance 230471. The applicant is Melba Mersed. This application is out of order to be heard and being continued to the November 20th, 2023 Land Use Hearing Officer hearing. Item A3, Special Use 230481. The applicant is David Wright, TSP Companies, Inc. This application is out of order to be heard and is being continued to the November 20th, 2023 Land Use Hearing Officer hearing. Item A4, Variance 230590. The applicant is Yenny Gerald Perello. This application is out of order to be heard and is being continued to the November 20th, 2023 Land Use Hearing Officer hearing. Item A5, Special Use 230746. Applicant is the Diocese of St. Petersburg, Incorporated. This application is being continued by the applicant to the November 20th, 2023 Land Use Hearing Officer hearing. Item A6, Variance 230829. The applicant is Tim and Jackie Dixon. This application is out of order to be heard and is being continued to the November 20th, 2023 Land Use Hearing Officer hearing. Item A7, Variance 230908. The applicant is Deborah Madvig. This application is out of order to be heard and is being continued to the November 20th, 2023 Land Use Hearing Officer hearing. Item A8, Variance 230925. Applicant is Mark Bentley. This application is out of order to be heard and is being continued to the November 20th, 2023 Land Use Hearing Officer hearing. Item A9, Variance 230965. The applicant is HB Alliance LLC. This application is out of order to be heard and is being continued to the November 20th, 2023 Land Use Hearing Officer hearing. And item A10, Special Use 230966. The applicant is Thang Lock LLC. This application is continued by staff to the November 20th, 2023 Land Use Hearing Officer hearing. This concludes the continuances and withdrawals.
All right, thank you. All right, the agenda today consists of items that require a public hearing by a hearing officer. I will conduct a hearing on each item today and will submit a decision within 15 working days after the conclusion of today's public hearing. My decision will be filed with the clerk of the Board of County Commissioners. The hearings today will be informal. I will ask questions related to the scope of direct testimony and may call and question witnesses as I deem appropriate. I will decide all questions of procedure. I will take evidence, but will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimonies shall be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding of fact unless it would be admissible over objections in a civil court action. The presentation today shall be as follows. For variances, staff will call the case. Development Services Department will have 5 minutes to present its report and findings. The applicant and the applicant's witnesses will have 15 minutes to present the proposal. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. County staff will have 5 minutes to present any amended findings or comments, and the applicant will have 5 minutes for rebuttal or summation. For special use cases, county staff will call the case. The applicant and the applicant's witnesses will then have 15 minutes to present the proposal. Development Services will have 5 minutes to present its report and findings. Planning Commission will have 5 minutes to present findings of compliance or non-compliance with the comprehensive plan. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against a proposal. And county staff will then have 5 minutes to present any amended findings or comments, and the applicant will have 5 minutes for rebuttal and summation. The 15 minutes that are allotted to proponents and opponents is the total time for those speakers. So if there are a number of persons who wish to speak on an item, the 15 minutes will be distributed among those persons. You may also appoint a spokesperson to represent your views if you wish. When you come to the microphone today, please state your name and address for the record. The meeting is being recorded, so please speak into the microphone clearly so your testimony can be recorded. And when you're finished speaking, please see the clerk to my left here to sign in. Now we'll hear from the County Attorney's Office on procedures for appeal of the Land Use Hearing Officer's decision.
Mary Dorman from the County Attorney's Office. This Land Use Hearing Officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, county staff, and any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. 1, the applicant, or 2, anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the County Attorney's Office to ensure that no new evidence or testimony is allowed before the Appeals Board that was not presented to the hearing officer at today's hearing. The County Attorney will recommend that the Appeals Board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the Appeals Board that is outside the record created at today's hearing could jeopardize the legality of the Appeals Board decision, and the presenter of that evidence could hurt their own cause. The safest course of action, then, is for you to write down any comments you make today and repeat them to the Appeals Board.
Thank you, Ms. Dorman. All right, all testimony today must be under oath, so if you plan to speak, please stand and raise your hand to be sworn in. Anyone online, please also raise your hand to be sworn in. All right. Do you swear or affirm the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
I do. I do.
Thank you very much. All right. Ms. Marshall, we are ready to hear the first case.
Today's agenda, we have no vested rights, which takes us to Section C, fee waiver request. Item C1, fee waiver 23-1059. The applicant is Jonna Elizabeth Allen. The applicant requests a fee waiver based on the basis of staff error. The administrator is not authorized to grant fee waivers in such circumstances. Therefore, the subject request must be reviewed for approval of an exception by the Land Use Hearing Officer. Per DRPM Section 9.7G, the Land Use Hearing Officer shall conduct an independent review of the request based on the criteria herein and the testimony at the proceeding. In granting an exception, the land use hearing officer shall be required to find extraordinary financial circumstances, emergency, catastrophe, or staff error which are outside the scope of the administrator's authority to consider. Building Division staff has provided a summary of the permit history in this matter and a copy of the building permit file SF002821, which is attached to the report.
All right, thank you. Applicant? Good morning.
Good morning, Madam Hearing Officer. The papers that I passed out are in the backup. However, the narrative is a revised narrative that just recognizes the folio that the error was conducted on in terms of the permit issuance.
Can you state your name and address for the record, please?
I'm sorry, Joe Moretta, Gardner, Brewer, Hudson, 400 North Ashley. Okay, the slides look different over here, but we're all good. This is a request for an exception to a fee waiver. As Colleen explained, we're looking for a fee waiver based on staff error that was committed in 1992. Just to give you a little context of what's going on the site, there's two separate folios. On the north parcel, which is 511 Telfair, there's a single-family home and a metal garage. On the south parcel, single-family home. That is where the permit was issued. It was considered a separate non-conforming lot in 1992. This is an aerial, so you can just see a little bit more what's going on there. And just as a side note, we have a survey that depicts both folios with that property line in between both of the folios outside of the garage. And we had discussions with staff on that. We believe there's a GIS error, so we will be looking at that as well in terms of trying to resolve that before the rezoning occurs. As I mentioned, in 1992, there was a permitting error. We have evidence of that from the building department. Colleen obviously provided you with the actual single-family permit itself, and the building department has acknowledged that in 1992, the south folio was considered a separate non-conforming lot. We did have discussions with the current staff and tried to go through numerous different options of how this might be reconciled. The current staff has a perspective that the subject lots would not meet the criteria for nonconformity certification, which really leaves the applicant with two options. They could either demo the site where the permit was issued, or at least one of the homes on one of those two folios, or they could rezone. The applicant has chosen to rezone, which is why we're here to seek the fee waiver. There really isn't a lot more to say than that, but they're left with a dilemma. They're going to have to spend money one way or the other. And even in the permitting, they're going to have to renew a lot of things like surveys that are very costly. Having said that, this is not to blame anybody. It's just things happen. And in this case, we're seeking some relief to try to be able to apply that towards the rezoning and subsequent permitting. So that's really everything in a nutshell, unless you have questions. I know there's a lot of other cases behind me, so I'll move out of the way.
I don't have any questions for you. I've reviewed the file and the documentation, so no questions for you right now. Thank you.
Thank you.
We do need your address for the record, though. I need you to state it in the record for audio purposes, please.
400 North Ashley.
Thank you.
Okay. Thank you.
Okay. We do take public comment on fee waivers. I'm not sure. These come rarely, procedurally. Okay. I'll go ahead and take public comment then. Is there anyone here or online who wishes to speak in support of this request? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this request? All right, not hearing anyone. And staff, anything further?
No, thank you.
Thank you. Applicant, anything further?
No, ma'am. Thank you.
All right, thank you. This closes the hearing on item FW 23-1059.
We have no remands or reconsideration requests on today's agenda, which takes us to section F, site development variance request. Item F1, variance 230920. The applicant is Michael Redhead. The request is a variance to encroach into the wetland setback. Staff findings will be provided by Wayne Doyen.
Hi, my name's Lori Redhead, Michael's wife.
I'm sorry.
Can you hear me? We live at 2606 Carroll Lake Street, Tampa, and we live on Lake Carroll, and we would like to build an open-air covered cabana for entertainment and shaded use. Our existing pool does not have a lot of deck space, so there's nowhere to be able to do this, and the other two areas of our yard back there are very narrow, and the dogs use them. Our pool, and I also wanted to talk, so this would go into the wetland encroachment. Also, the county paperwork had that the pool was moved in 2005. At least that's the way I interpreted it. It was actually built in the 1970s. It was renovated by the previous owner in 2005. They did new pebble tech, new waterline tile, and put thin pavers over the existing original concrete decking. I think they also put the hot tub in at that time. I spoke to them. They got all the permitting that was requested, and I called the pool builder they used, which was Landmark Pools, who also built the pool in the 70s, and that information's on microfiche, and they weren't willing to find it for us. There are quite a few examples on the lake of pools and or homes and or pools built way within the 30-foot wetland setback, some as little as 10 feet. I didn't include them in the package. I do have some pictures of some with me, but they're on paper. So I don't know if you want those or not.
Ms. Redhead, just one moment.
Yep.
Could I make sure that microphone's turned off over there where there's some comments going on, because thank you, it's a little disruptive. Thank you very much. Do you have anything further?
No.
Okay, just some questions for you. The single-family home on your property.
Yes.
It appears it was built in 1973. Does that sound about right?
Yes.
Was the pool built originally around that same time?
Yes.
Okay. And then in 2005, the original pool was renovated.
Correct.
Okay, so the pool hasn't moved.
Correct.
Okay. And then you want to build something new today, and I'm looking at your file, the survey that's in the record. Where is the new structure you wish to be?
So it's to the right-hand side of the pool if you're looking at the lake, which is south.
Okay, I see it. So as far as where the pool sits, it encroaches not into the wetland, but into the wetland conservation area setback.
Correct.
Okay. Then the new structure would be basically in that same area. It's not going to go out further into toward the wetland, right?
No, it goes, a small part of it goes to the edge, but that's actually wood decking.
Okay.
So it would have drainage.
Okay. All right, I see it on your survey. Is that new structure then, you said, will it be built up off the ground?
So
will there be drainage under
the square
it?
part is concrete.
Okay.
So it would be level with the pool decking.
Okay.
And it would have a stem wall.
Okay. All right, I see it on your survey then. That's all the questions I have for you.
Okay.
Thank you.
Do I need to stay?
Step aside while we take public comment. Or
Okay.
did you have someone else speaking for you, or? No. Okay, thank you. You can step aside, and
We haven't had the staff summary.
Oh, I'm sorry. I thought that's what you presented. I apologize. Well, we're going backwards this morning. Staff summary, thank you.
Good morning, Wayne Doyen, Hillsborough County Natural Resources. The applicant is requesting a variance from a 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown in the site plan submitted on 8/16/2023, is to allow for the construction of a cabana within the 30-foot wetland conservation area setback. The applicant also requests an after-the-fact variance for existing swimming pool with deck within the 30-foot wetland conservation area setback. Section 4.01.07.b.4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within the required 30-foot wetland conservation area setback. 29.5-foot encroachment from existing pool and deck and proposed cabana, 0.5-foot setback, findings none.
All right, thank you very much. All right, is there anyone here or online who wishes to speak in support of this application? I do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, do not hear anyone. Development Services, anything further?
Nothing further, thank you.
Thank you. Applicant, anything further? All right, thank you very much. This closes the hearing on variance 23-0920.
Next item is item F2, variance 230934. The applicant is Stephen Tonking, U.S. Pools. The request is a variance to encroach into the wetland setbacks. Staff findings will be provided by Wayne Dine.
Good morning, Wayne Doran, Hillsborough County Natural Resources. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown in the site plan submitted on 10/4/2023, is to allow for the construction of a swimming pool and deck with a 30-foot wetland conservation area setback. The applicant also requests an after-effect variance for existing fence within the 30-foot wetland conservation area setback. LDC section 4.01.07.b.4, LDC requirement, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a 30-foot wetland conservation area setback. 22-foot encroachment for proposed swimming pool deck and existing fence, 8-foot setback as a result. Findings, a wetland setback compensation planning plan has been provided on the site plan dated 10/4/2023 that provides equivalent square footage of compensation planning to the amount of encroachment.
All right, thank you. Applicant?
Good morning. Amber Marker. I'm representing U.S. Pools and the homeowner. Do you need the property address or, okay. For the property 17104 Crawley Road in Odessa, Florida.
Okay. Did you need the speaker's address too? Yes.
My address is 184 Sanctuary Trace, Crystal Beach, Florida. And we're requesting permission to construct a swimming pool within the wetland setback. Due to the layout of that wetland setback, there's no other suitable place on the property for them to build the pool.
Okay. And it shows, I believe, there's a single-family home on the property.
Correct.
That home was built in 2020, is that correct?
I believe so.
Okay. And there was no plan for a pool at that time?
I don't know. The current owner just bought the property, so the home was already there.
Okay, I see. All right, and the alleged hardship then is simply that they want to build a pool, and it appears that the house is built all the way up to the 30-foot conservation area setback.
Yes, the area goes kind of like in a V, so it encompasses the entire rear of the property and up to the sides also.
Mm-hmm. Okay, I see. Yeah, I see on your survey. All right, anything further? I guess You didn't address the fence. Where is the fence exactly?
So there is currently a fence there along the side, and we did add that into the site plan. Obviously, we'd have to continue the fence for safety purposes, but it's proposed to be in the same place it already is.
All right, so the fence is existing. What kind of fence is it?
It's a black wrought iron fence. I think it's 5 feet high.
I see. And which side of the property does it exist on?
I believe it's on both. I do have a picture somewhere of the existing.
Okay, so it exists on the side yards, not across the rear yard?
No, not across the water, just on the sides.
Okay. And I guess the hardship criteria related to the fence?
Well, for the pool safety purposes, they would have to have a fence of some kind.
This is not around the pool, though, right? This is on the
No,
property.
it's across both sides of the property.
Okay, all right. All right, is that it?
Yes, that's it. Thank you.
All right, thank you. All right, is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? I do not hear anyone. Development Services, anything further?
No, thank you.
All right. And applicant, you didn't have anything further, is that correct? All right, thank you. This closes the hearing on variance 23-0934.
Next item is item F3, variance 230964. The applicant is Drury Development Corporation. The request is a variance to encroach into the wetland setback. Staff findings will be provided by Wayne Doyen.
Wayne Doyen, Hillsborough County Natural Resources. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B. Point 4 of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on 9/22/2023, is to allow for the construction of a portion of a building, parking lot, fence, sidewalk, and retaining wall within the 30-foot wetland conservation area setback. LDC section 4.01.07.B.4. LDC requirement, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetlands conservation area setback. 30-foot encroachment for a portion of the building, parking lot, fence, sidewalk, and retaining wall. Result, 0-foot setback. Findings, a wetland setback conservation planting plan will be provided on the construction plans reviewed through the site construction intake process.
All right, thank you. Applicant?
Hello. I just have a presentation really quick. This piece. I could just open it from here, right?
Yep, it should be. And then go down to it should be your slideshow to make it full screen. And then you have to click through here or use these buttons right here to go back and forth.
Okay. Bryce Pinson with Half Associates here representing the applicant, 1000 North Ashley Drive. And the applicant, Jared, with Drury Development, is here, and also our environmental scientist is here as well if you have questions later. So the property is located off of East Admo Drive and Falkenberg Road. It's about 5.42 acres. It's a part of a planned development approved for a hotel and restaurant. The request is to reduce the wetland conservation area setback from 30 feet to 0 feet with a retaining wall provided to protect the wetland. The blue line is where the 30 feet would be. The red line is where the proposed 0 feet would be with the retaining wall. So over the last few years, the applicant has been working with EPC to reduce the size of the approved development area in order to minimize the wetland impacts. The building and everything has been shifted to minimize the impacts as much as possible, and the retaining wall is there to also help protect the new wetland line. So the request to reduce the buffer and conserve the wetland area has already been conceptually approved by EPC. How this is unique to the subject property is that the buildable area is very highly constrained because of the wetlands. And just to clarify, the wetland area is actually only on the eastern portion. That southwestern portion is just a retention pond area. But the site is narrow and irregularly shaped. There's also a shared private access drive on the south, which dictates the access location. And these features are unique and singular to the subject property. How this is consistent with the Land Development Code and Comprehensive Plan is that the future land use of the site is RMU 35, which allows a max FAR of 2.0. Currently, the proposed development is only asking for, or approved for a max FAR of 1.0 because of the planned development layout of the hotel and restaurant. And that's just because of the buildable and area, the uplands available on the site. And for the uses, there's already existing hotels to the south, and it's located in a commercial area. And allowing for the wetland conservation area setback request would allow this site to be developed as it has been approved under the current PD and with the EPC conceptual approval. And then the compensation planting plan will be provided at the construction plans, as staff mentioned, with the site construction intake process. And so that's all I have, unless you have questions.
Could you just go back to the slide right before this one, please? Thank you. So this is the existing site, is that correct? The way it looks today?
Correct.
And then I'm looking at your site plan compared to this, and it looks like there's quite a bit of open space being left up near, I guess that would be to the west, the northwest, near, I don't know if that's Falkenberg Road. What is that area, that open area going to be?
That's where the restaurant is going to be, and the parking for the restaurant.
Okay. So in the redevelopment of this site, then the hotel is being pushed back to the east, southeast, so that there can be a restaurant up front.
Correct. And I actually have the PD site plan, if you want me to show it in the...
Oh, okay, that might be helpful, thank you. Is that in the record, do you know?
Well, this is already approved.
Well, bring the microphone down so I can hear your answer.
This is already approved, so it's not, it's in the record.
It's in the PD zoning?
Yes.
Okay, thank you. And when you move down there, just bring that microphone with you so we can hear you. That's it. Thank you very much.
Sorry. And how do I, oh, you got it. So this area over here is where the restaurant building area and parking envelope is.
Okay,
So
I
that's
see.
what's not on the site plan for the wetland impact area.
Okay. All right. That's very helpful. Thank you.
Okay.
That's all the questions I have for you.
Okay.
Be sure and sign in with the clerk. All right, is there anyone here or online who wishes to speak in support of this application? I do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, do not hear anyone. Development Services, anything further?
No, thank you.
All right, thank you. And applicant, you had nothing further, is that correct? Thank you. All right, this closes the hearing on variance 23-0964.
This takes us to section G, sign variance request. Item G1, variance 230938. The applicant is Mark Brenchley. The request is a variance to sign requirements. Staff findings will be provided by Sam Ball.
Good morning, Sam Ball with Development Services. I submitted a revised staff report for some corrections. I believe I need to give 2 copies.
All right, submitted to the record, and I do have a copy of it. Thank you.
Oh, okay. Okay, so the applicant is requesting 3 sign variances in order to accommodate three wall sign replacements on the northwestern, northeastern, and southwestern elevations of JCPenney's at Brandon Town Center. According to LDC Section 730A2, concerning maximum wall sign area, each premises, and in the case of multi-occupancy buildings, each unit shall be permitted to display building signs, the aggregate sign area not to exceed 1.25 square feet per linear foot of building frontage facing a public street or parking lot, but in no event more than 200 square feet of aggregate sign area per elevation. Using the 1.25 square feet per linear foot of elevation for the northwestern and southeast building elevations, each having 186 feet of frontage, and the northeastern elevation with 375 feet of frontage. All the elevations are allowed up to 200 square feet of aggregate sign area. The applicant is requesting a 50.25 square foot increase to the allowable sign area on the northwest and southeast elevations, which would allow for 250.25 square feet of sign area on each of those elevations, and a 127.21 square foot increase to the allowable sign area on the northeast elevation. The current signs were approved under a master sign plan in 1994, which allowed 319 square feet of wall sign on the northeastern elevation, 194 square feet of wall area on the east, and 187 on the west elevation. But because the master sign plan is no longer contained within the LDC, the sign on the northern elevation is non-conforming and may not be replaced unless the sign replacement complies with the current code requirements and restrictions. That concludes my report. If you have any questions.
No questions for you. Thank you.
Okay, thank you.
All right, applicant.
Good morning. My name is Mark Brinchley. Address 3790 Beacon Ridge Way, Claremont, Florida. I am the agent, the authorized agent for the owner of the property, CTL Propco 1 LLC, and JCPenney is the tenant in that building at the Brandon Mall. As Sam mentioned, the sign code allows so many square feet of sign per 1 foot of building frontage facing a public street. This is a unique site because there is no public street that this building faces. It faces a public access owned privately by the Brandon Mall. And you see, it's a ring road. A ring road goes all the way around the mall. Here is JCPenney, and those 3 building walls that Sam mentioned. And to reinforce the fact that these signs are almost 30 years old, the master sign plan was approved in 1994, and they obviously were determined to be reasonable at that time, even though they exceeded the maximum sign area of 200 square feet. And they have been on the building now for 29 years, and they clearly do meet the unique and the hardship issue because the sign plan has expired, and now if they wish to replace the signs, and this is part of a rebranding effort, a national rebranding effort. Let me show the signs. How can I zoom? I wish to show the comparison between the existing and the new.
Far in. Is that good for you, or you want more?
A little bit more. Great. Oh, thank you.
Go back and forth this way.
Oh, thank you.
Come out for you. That was a minute.
Thanks. The top sign is the original, basically a brown face. The bottom is white with black outline. And it's a little curious to me why they would go with a white background on a very light wall, but I guess they feel the black border is going to offset the challenge of the sign. Again, the southeast elevation, the very same thing, rebranding, going to the white face. The signs are almost identical in size. They are at the exact same location, so they could utilize the electrical connections and so forth. This is the north elevation. The one on the left is, of course, the existing. One on the right, which is hard to see, is the proposed rebranded sign. We have received one positive comment, and I'm sure that will probably be read into the record by the management of the Brandon Mall. If there are any questions?
I don't believe I have any questions for you, Mr. Branchley. Thank you.
Thank you.
All right, is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? Do not hear anyone. Development Services, anything further?
Nothing further. Thank you.
All right, thank you. And applicant, anything further? Nothing. Okay, thank you. This closes the hearing on variance 23-0938.
This brings us to section H, variance requests. Item H1, variance 23-0378. The applicant is Jose H. Ramirez. The request is a variance to lot development standards. Staff findings will be provided by Tanya Chapella.
Good morning, Tanya Chapela, Development Services. The applicant is requesting a variance to lot width requirements. This variance is related to a parcel subdivision for an existing parcel, zone AS-0.4. Per the Land Development Code, section 60101, the required minimum lot width for property zone AS-04 is 150 feet. The applicant requests a 33.89 foot reduction to the required front yard setback to allow a lot width of 116.11 feet. According to the Hillsborough County property appraisers records, the lot was created in 1996 after the zoning conformance date and cannot be deemed as legally non-conforming. There is no record of a subdivision approval for the subject property. Subdivision review and approval through the Development Services Department shall be required following any variance approval. Thank you. This concludes my presentation.
All right, Ms. Chapella, just looking at the applicant's survey in the record, it looks like it's sort of a flag lot configuration.
Yes.
So the part of the property that is on the road frontage, is that the part of the property that is the 116-foot width?
Yes, it is correct.
Okay, thank you.
The situation was the larger portion of the lot to the south is not meeting the minimum lot size for that zoning district. So the applicant decided that he had two options, either go through this variance, like it was a regular lot, not a flag lot, but a regular one. But he decided to, to go this way, because otherwise the variance should have been for the minimum lot size in a flag lot. And anyways, I'm just giving too much information,
That's all right.
but yeah.
That's all right, thank you. Okay, and we'll hear from the applicant.
Good morning, everyone. I'm sorry, I'm kind of sick. My name is Jose Ramirez. The address is 6265 West Dormany, and I'm here for the variance. I'm just want to have that permit to build a house in there.
All right, Mr. Ramirez, were you, when did you acquire this property?
Pardon me?
When did you acquire this property?
When do I bought the property?
Yes.
But 8 years ago.
8 years ago?
Mm-hmm.
All right. And was it already subdivided this way when
Yes.
you bought it?
Yep.
All right. Were you involved in the subdividing of this property at all?
Nope.
Okay. And when you bought it, was it your intention to build a house on it?
Yes.
Okay. And all right. I believe that's all my questions for you.
All right. Thank you.
Did you have anything further to add?
Nope.
Okay. All right, thank you.
Thank you.
All right, is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? I do not hear anyone. All right, Development Services, anything further?
Nothing further.
All right, thank you. Mr. Ramirez, is there anything further you wish to say? Okay, nothing further. That closes the hearing on variance 23-0378.
Next item is item H2, variance 230594. The applicant is Plato Academy, Tampa. The request is a variance to LDC parts 3.10 CPV standards and 6.07 fence and wall requirements. Staff findings will be provided by Israel Monsanto.
Good morning. Israel Monsanto Development Services. The applicant is requesting today variances for the requirement found in the Land Development Code, Sections Part 310.00, the Citrus Park Village Development Regulations, and also 607.00, fences and walls. This site is located in the Citrus Park Village sub-districts A1 and A5. The site is currently occupied by a private school. The Citrus Park Village Development Standards requires specific standards for chain link fences, including placement, type, and color of the cladding and plantings along these fences. Additionally, per the Land Development Code, fences regulations, fences on front yards are limited to a maximum height of 4 feet. According to the variance application and property survey, there is a 6-foot high chain link fence currently surrounding the school perimeter. The chain link fence contains a blue fabric material utilized to screen the school property, and also there are no plantings provided to meet the Citrus Park Village standards. The 3 variances requested today are: fences over 4 feet in height shall not be allowed within the required front yards. The variance is for a 2-foot height increase for the chain link fence along the front yards. The second variance request is in the Code 607.02C1D. In general, the design of fences shall be in keeping with the neighborhood appearance. Fences may be constructed of commonly used materials, such as chain link, masonry, wood, or PVC. The variance requested is to allow the use of a material, which is a blue fabric, over the chain link fence, which is not commonly used in this area. And the last variance request is that chain link fences shall be clad in green, brown, or black vinyl, and all sections shall have top rails. Additionally, evergreen vines such as Confederate jasmine, coral, honeysuckle, or beech elder shall be planted along the entire length of this fence, excluding gates, and these are to be no more than 6 feet apart on centers. Said plants shall be in 3-gallon containers at a minimum at time of plantings. The variance for this is to eliminate the chain link fence cladding and also the required plantings. Madam Hearing Officer, staff conducted a research about when the fence was placed there, just to see if it was qualified for a legal non-conforming fence, but it was very difficult to establish it. So that's what we advised the applicant to also include the chain link height for the variances. And also this site is under code enforcement violation for the materials being utilized. And we're available if you have any questions.
That's all. I don't have any questions for you. Thank you.
Thanks.
All right, applicant?
Good morning. Stephen Donnelly, the authorized representative, address 5327 Street, St. Pete. So I'm here to represent Plato Academy as the representative. The variances, one is the main one. Our concern is for the fabric hanging over the fence to protect and shield our students from outside people to be able to look in. The other variances were suggested based on the time of when the fence was put in and the style of fence that it was. This was not something that Plato Holdings had anything to do with. It, as far back as we can find verbally, is somewhere around 2001 is when that fence was installed. When we purchased the property, 2017-18, we just simply picked up where left off. The original shading was blown off one of our hurricanes that came through a few years ago, and the new shade was added up just simply to, make sure our students were shielded from Gun Highway and the other areas of high traffic.
Okay, so you acquired the Plato Academy acquired the property in 2017, you said? And the fence was already covered with the blue fabric.
It was a black fabric at the time, but because the hurricane destroyed so much of it, we just replaced it all.
And when was that done?
That year, do you remember? 2022. So
Okay.
just over a year ago.
All right. What is the hardship in providing the required plantings?
That was something that we were not ever told about upon purchase. So again, the variance suggestion was so that way that we would not be held accountable to something that might have happened a decade before we purchased.
Okay. Is there any reason why the plantings could not be provided?
Budgetary would be the main one for a charter school. We're based on public funding. So to provide those plantings on a code that was in place before the fence, or before we acquired the fence through purchase.
What about the color of the cladding?
There was a silver chain link fence that was already in place. So the cladding around it wouldn't be something that we would have to replace the entire perimeter of the school to be at the code that we're asking for the variance.
In other words, you would have to replace the entire fence.
Yes, the entire perimeter we're speaking of.
Okay. And the reason, just from reviewing the record, you want the fence covering there to provide privacy, is that correct?
Correct, yeah. Privacy, just to make sure that you can't look through a wide open chain link fence, that's all.
And
as
how-
any school would wish to have some.
Thank you. And how tall is the fence?
6 feet going around the perimeter.
And the cladding on a chain link fence, would that provide privacy?
Not that I'm aware of, no.
Okay. And the blue fabric that's on the fence, does that go around, does that cover the fence around the entire perimeter of the school?
Yes, it does.
Okay. And it wasn't there before, there was something else there before, but it was destroyed or damaged or removed by a storm?
Correct, yeah. There was originally the black shield, you could say, the shade around it. When it was blown off and ruined, we just purchased a new one. We didn't realize we would be out of code based on any previous experience.
Okay.
Because the black shade was on there before Plato purchased as well.
Okay. All right. That's all my questions for you.
Okay, great.
Make sure you sign in with the clerk.
Will do. Thank you.
All right, is there anyone here or online who wishes to speak in support of this application? Please come forward. And you're speaking in support of the application. How many persons wish to speak? Are there 4?
Yeah.
All four of you are speaking? Okay. So how about three? You get about between 3 and 4 minutes apiece, okay?
Thank you so much. I was told by your assistant to let you know I have not been sworn in, if that makes a difference.
Yes, please raise your hand to be sworn in. Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Hi, good morning. I just want to thank you for your time.
We need your name and address for the record.
My name is Barbara Fideli. I live at 6313 Nicky Lane, Tampa, Florida. I'm the parent of 2 students at Plato Academy, Tampa. Do you need the school address?
No.
Okay. I want to be respectful of your guys' time, so I'll try to keep this within your guidelines. We are here today for you to rule on a grievance brought forth by a neighbor behind our school, Plato Academy, Tampa, regarding the windscreen attached to our fence that protects our students. When you make your decision today, I ask that you consider these 2 things prior to your ruling. In 2023, Governor Ron DeSantis signed into legislation with House Bill 1421, which were updates to current school safety measures that were put into place by the recommendation of the Marjorie Stoneman Douglas High School Public Safety Commission. In this legislation is State Statute Rule 6A-1.0018, which requires all public and charter schools by state law to have adequate fencing of at least 6 feet in height surrounding their school for perimeter safety measures. During the passing of HB 1421, Florida state legislators had a discussion pertaining to what is considered adequate fencing. Chain link fencing in particular was debated. There was a valid concern that chain link fencing wouldn't provide adequate perimeter safety as it was easy for a perpetrator to climb up or see through for criminal surveillance. It was decided by the state and Hillsborough County schools that adding a windscreen to a chain link fencing would resolve the issues stated and would meet adequate perimeter safety guidelines. The grievance our neighbor brings forth is being backed by an antiquated city ordinance. I would hope that Florida state law would supersede any county or city ordinances, especially when it pertains to the safety of our students and staff at our schools or any school in the state of Florida. I understand that the windscreen may be an eyesore, I truly do, but the safety of children should never have to live in a world where they even have to worry about such things as an active shooter on campus and the possibility of mass casualties. I would hope that the safety of the students is more important than to protect would be more important than that of a protective windscreen being an eyesore. So I ask you to please rule in favor of Plato Academy being able to keep our protective windscreen on our fence as a safety perimeter fencing and to allow us to keep the required height by state law of 6 feet. Thank you.
Please sign in with the clerk, ma'am, before you sit down. Right over here. Thank you.
Good morning. My name is Beatrice Botball. Address is 8321 Golden Prairie Drive, Tampa, Florida. My incredible daughter is in 7th grade at Plato Academy. She has been a student there since its inception in Hillsborough County. Our small but mighty campus doesn't have the luxury of public schools, having acreage and land around its property. Without the privacy fencing, people would have direct access to our kids, their schedules, our school protocols, and flow. In this day and age, that open access is dangerous. We need to protect our children from not only potential mass casualty situations, but also the potential of sexual exploitation. In driving around our campus, there are only 2 homes that front face the campus. One has its own 3-foot privacy fencing, and the other is known for constantly hosting gatherings within the neighborhood. I have video of this if you'd like to see it. Since this neighborhood is not an HOA area, I feel there are many other eyesores within it that we can focus on that would not put children's lives in danger. If the concerns around the fence, the privacy fencing is the color blue, I don't understand this concern. Our sky is blue, our oceans are blue here in Florida, And according to the definition itself, the color blue represents calm and peace. I hope that you vote to protect our kids at all costs. Thank you for your time.
Thank you. Next, please.
Good morning. My name is Heather Jenkins. My address is 6816 Muncaster Court in Tampa. I am actually the principal at Plato Academy, and I am the one responsible for everything that happens at that school, good and even the things that are dangerous. It is a very heavy task as a principal to have to worry about children's safety and worry about someone gaining access to our school. The chain link fence was there when we bought the place, but I'm not sorry that it's there. It's 6 foot tall, which means it's very difficult. No one could just hop that fence. You would have to climb it. And so when we did our security walk around with Hillsborough County Sheriff, we talked about that. How could we prevent people from climbing these fences to get into our school property? And one thing they suggested was putting up this privacy screen around it. It's on the outside of the fence, so no one can gain a foothold in the chain link fence. You would not be able to climb up over the fence. So it is providing privacy, as my wonderful parents have mentioned. It's providing privacy for our students. It's providing safety. It's also keeping out unwanted eyes. We've had, before we put it up, people walk around and they stop and they try to peek in at our students. It's very disconcerting for the staff and for the students. We have 22 registered sex offenders just in the neighborhood around our school. So it's very important that we keep our children safe. And when I received notice that there were people wanting us to take the safety screen down, I can't understand it. I can't understand why anybody would want to do something that would make kids less safe. So this is, and I take all of this very personally. My daughter is a student at that school, so she is my all-in bet. I need to keep this place safe for her and safe for everyone else. Thank you.
Thank you.
My name is TJ Brubaker. Address is 16021 Timberwood Drive. I am the head of maintenance for all 9 Plato campuses in Tampa, Hillsborough, and Pasco and Pinellas counties. I have also been a parent of students to the previous school, Citrus Park Christian School, since 1996. And the 6-foot fence has been there the entire time that I'm aware of, never been changed as I was a parent there. I now have 3 grandchildren at Plato Academy, Tampa, and I wish to see that their security be provided for as best as possible. In the maintenance aspect, providing irrigation to supply plantings for the fence would be virtually impossible because of the property configuration itself. That's all I have.
All right, one question for you.
Yes.
As I understand, you said you have knowledge of this 6-foot-high chain link fence at this location?
Correct.
Going back to approximately what year?
I do not remember exactly when it was changed from 4 to 6 foot fence. I believe it was probably somewhere around the September 11th attacks in 2001.
Okay. But do you recall it was 4 feet at some point in time?
At some point in time, there's still evidence on the property there was 4-foot fence.
Okay. And I guess just to confirm then, you have firsthand knowledge. You saw this, right? That it was a 4-foot fence and now it's a 6-foot fence?
No, I never saw 4-foot
Okay.
fence, but I know that there is 4-foot fence and evidence of it.
Evidence that it was there before?
Long gone.
Okay. And so then I should ask, you have personal knowledge of there being a 6-foot-high chain link fence, and you believe it might go back to as far as 2001. Is that correct?
Correct.
Okay. Is there any reason you think it might have been around that time other than the 9/11 attacks?
Security concerns.
Okay. But you don't have, in other words, other than security concerns, as far as your memory goes, you don't recall when that 6-foot-high fence went in exactly?
No, I do not.
Okay. All right. That's all I need. Thank you so much. All right. Anyone, please come forward. Thank you. This is speaking in support of this application. You have 6 minutes left.
I was going to say, I know we're trying to make
That's
sure we're
fine.
sensitive to time. I do need to be sworn in. I'm sorry.
All right, yes, sir. Thank you. Raise your hand. Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. My name is Joseph Frett. My address is 14301 Arbor Hills Road, Tampa, Florida. I am a parent also at Plato. My son is in 8th grade, which definitely he is one of the ones that would be able to, in an event, hopefully defend himself a bit, even though he is a bit undersized. But my concern is for the smaller children. Plato is a K-8 school, an amazing school. I thank Principal Jenkins for welcoming my child, as he wasn't always there, but he's now a part of the Plato family, and our family is that family as well. Maybe I watch too much Dateline and I'm too concerned with certain things, but when we have the opportunity to protect our children, we should. As I sat here and I listened to all the preventative measures in place for wetland setbacks and the environment, I'm thinking, well, the biggest thing that we have as far as our resources are our children. And if we have the opportunity to protect them, which Principal Jenkins and the Plato staff are doing to the best of their abilities, we should continue that. And that's pretty much all I have to say.
All right, thank you, sir. Be sure and sign in. Thank you. All right, is there anyone else who wishes to speak in support of this application? This is in support. Yes. Please come forward.
My name is Vladimir Huchko. My address is 14814 Herricold Court, Tampa. My child is a student in Plato Academy. I am very satisfied how he's running this school, what he's doing for safety of children. And I feel this is very important. This fence is going to stay such a way, not just for privacy, but for safety. And I hope it's going to stay such a way. Thank you.
Sir, thank you. All right, is there anyone else who wishes to speak in support of this application? All right, do not hear anyone or see anyone. All right, is there anyone else, is there anyone here or online who wishes to speak in opposition to this application? All right, I do not hear anyone or see anyone. Development Services, anything further?
Nothing further.
All right, thank you. Applicant, did you have anything further? No, okay. Thank you. This closes the hearing on variance 23-0594.
Next item is item H3, variance 230949. The applicant is Vijay Patel. The request is a variance to maximum wall height. Staff findings will be provided by Carolyn Petal.
Good morning. Carolyn Petal, Development Services. This is variance 230949. The applicant is requesting a variance on a property zoned AR for a proposed 8-foot perimeter wall along the front and side property lines. LDC section 60702C1, a fence over 60701C1A. Fences over 4 feet in height shall not be allowed within the required front yards except for certain circumstances that do not apply to this case. LDC section 60702C1F, the maximum average height of any fence or wall shall be 6 feet, except for certain circumstances that do not apply to this case. Additionally, Keystone Odessa Rural Standards for Fence Requirements, LDC Section 30806B1, are not required for this property, as this wall is not being constructed, owned, or maintained by a developer, homeowners association, or similar entity. That concludes my report.
All right, thank you.
Thank you.
Applicant?
The applicant can't make it, so I was the,
okay.
my name is John Whitehead.
All right, Mr. Whitehead, we need your address for the record, please.
11339 Sandpiper Avenue, Brooksville, Florida.
All right, are you in the record appearing as an agent for the applicant?
I am, and this is a continued variance. Last year it was seen, and I was the applicant in that case, so I have familiarity with this, and I'm also an agent.
We have agent of record. Okay, thank you. If you're agent of record in this case, if we confirm that, are you going to present the case today?
I am.
Okay, one moment then.
We don't see his name in the record.
All right. All right, we don't have, apparently do not have an agent authorization in the record.
There's a Jarek Wygala as the authorized agent.
All right.
Wagasala? Yeah.
Who is that person? Are they with,
He works for our company.
it works for your company?
Mm-hmm.
Is the company named as an authorized agent?
No, unfortunately, just his name.
Just the person, okay. All right, well, in that case, then this case can't be heard today, is that correct? The applicant isn't here?
I just ask if there's a way to get a hold of the applicant.
I
Yeah,
can
and then see if
step
they
out.
could orally authorize you, if they could get online and get on the camera and authorize you. Otherwise, I don't know what you could do but continue it.
Okay.
Madam Hearing Officer.
Okay, thank you for that, Ms. Dorman. All right, so we're going to close the hearing on this one for now, and if you can get in touch with the applicant and see if they can appear online, let us know and we'll recall it, and they could authorize you orally. If you don't think you can do that, then we'll go ahead and continue this case until November.
I'll give it a try.
All right, give it a try. All right. Let us know, so we'll know whether to continue or not. And this is case 23-0949. We're closing the hearing on this case for now, and we'll proceed to the next case.
Thank you.
Next item is item H4, variance 23-950. The applicant is Madeline Davidson. The request is a variance to minimum lot size by available utilities. Staff findings will be provided by Michelle Montalbano.
Good morning. I'm Michelle Montalbano with Development Services. The applicant is requesting a variance to the required upland area for use of a septic system in a water resource protection area in the ASC1 zoning district. According to LDC section 6164, a minimum lot size of 1 acre of upland is required for the use of a septic system within a water resource protection area as shown on the Hillsborough County Resource Protection Map. The subject proposed lot, which is shown on the survey as Lot 2, has a total of 0.78 acres of upland area. Therefore, the applicant is requesting a variance of 0.22 acres of upland area for use of a septic system. Some staff findings, according to the Land Development Code, Section 611 and Note Number 2, up to 1/5 of the required lot area may consist of conservation or other wet areas which require density credits under the comprehensive plan. With the easement area included, the subject lot meets the requirement for the ASC1 zoning district with a total of 0.86 areas of upland and an overall lot size of 1.19 acres. I'm here if you have any questions.
Just to clarify, in the staff findings, it says including the easement area. And by easement area, is that referring to the access? Okay, which is
Correct.
actually part of the lot, right?
Correct,
Okay,
yes.
thank you.
Okay, thank you.
That's it? All right, applicant?
Hi, I'm Madeline Davidson. My current address is 13528 Avista Drive, Tampa 33624. My future address will be determined by this hearing. The technical information is going to be given by the surveyor, Amber Chu. I don't know if you want her to go first or you want me to go first.
We need your current mailing address on the record, please.
13528 Avista Drive.
Thank you. You can go ahead, please, and then we'll hear from Ms. Tu, okay?
Okay, I just wanted to give a little personal background about what we're trying to do with this property. I've been a Tampa Bay area resident since I moved here with my parents in 1970. My purchase of this property at 17900 Jurassic Road began with a dream in 2014. My husband died in 2013 after being severely injured in an auto accident in 2008. He probably should have died in the accident, but his strength of will kept him alive as a quadriplegic and in severe pain for every hour of every day for the next 5 years. Tragedies such as this either bring family members closer together or tear them apart. We were lucky and consider those to be our bonus years. During those 5 years, my husband was able to see our daughter graduate from college, both kids marry, and the birth of our grandson. About a year after my husband's death, my son told me he had a dream that our remaining family all lived in separate houses on a large piece of land. My first thought was, oh, how nice, he wants me, as I had always assumed that I would live close to my daughter as I aged. We had a good laugh about his dream and moved on. In the ensuing years, my whole family would periodically discuss this dream and talk about how it would work out, but we never took it seriously. Then COVID hit. We discussed implementing this dream and started looking for property. When my daughter and her husband, who is here in the audience, first found this particular property, I thought it was too big. But after visiting it, I fell in love. It seemed perfect. The realtor's documents at that time showed that it had been approved for a 3-lot split in 2015 with 3 3,100 square foot houses. So we thought we were set, although our plans are more modest. Our plans are for 3 houses, one for me, one for my son, his girlfriend, and their son, and one for my daughter and son-in-law. We plan to sow wildflower seeds on a great part of the land to encourage bees and butterflies. We want to make as little an impact on the land as possible and live in harmony with the wildlife we have already encountered, which include deer, wild turkey, and snakes. My house will remain in a trust, which will pass on to be split between my 2 children at my death. I intend to live well into my 90s, but no matter when I pass, the hope is to keep my house in the family. We have long-term plans to keep this as a family compound and to allow me to age in place with support from my children. I understand county regulations requiring a full acre of buildable land per household, but we consider the entire 4.5-acre property, including the wetlands, to belong to all of us as one cohesive unit. The proposed split is to legally allow each child to qualify for a mortgage and build their own home. I hope that your decision will allow us to live our dream, and thank you so much for your time.
Okay, and just to clarify then, the variance is only for Lot 2?
Correct. The other 2 lots meet or exceed the 1 acre without the wetlands.
And is there any way to divide the lots?
Apparently not, but Amber should be able to answer that question better than I.
Okay, that's fine. Thank you very much.
Thank you.
We'll hear from Ms. Tu now.
Morning, can you hear me?
I can hear you. I need to see you, I think. Oh, there. I think I have a, yes, I can see you. Go ahead, please.
All right, good morning. My name is Amber Tu. My address is 2002 Holloway Road, Plant City, Florida, 33567. I am the agent for Ms. Davidson, who owns the property at 17900 Jurassic Road in Lutz. As Ms. Montalbano stated, we are seeking a variance to the minimum lot size of 1 acre of upland that is required for the use of a septic system within a water resource protection area. Jurassic Estates is a proposed minor subdivision currently in review with Development Services. Upon the zoning review, it was determined that the property is located within the Wellhead Resources Protection Area, Zone 1. The proposed Lot 2 does have 0.7 acres of upland with 0.33 acres of wetland, and the easement accounts for the remaining 0.08 acres for a total of 1.19 acres. So for your question, it would not be able to be reconfigured we wouldn't be able to change anything as far as the lot size or the lot lines. It would be specifically, this variance would be needed to create the Lot 2.
Okay, so then, regardless how the lines are drawn, I guess, there's no way to render 3 lots with all 3 of them meeting the minimum. Is that correct?
Yes, ma'am.
Okay. All right. Anything further, Ms. Tu?
No, ma'am. Just without this variance approval, Ms. Davidson and her family will not be able to create the new lots so that her children will be able to build their homes.
Okay. All right. Thank you very much.
Thank you.
All right. Is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application?
My name is Barbara Randolph. I live at 17905 Gerasi Road in Lutz. My property, the back of my property actually joins exactly where they're wanting to make this adjustment. I've been in my home for 53 years. I can appreciate everything that she said. My property does join that property in question. And the entrance to their property in the back runs the whole length of my property as well. It's only about a 30-foot entrance for their entire property. That property, I believe, has sold about 4 times in the last 2 years. And several of the people wanting to buy it wanted to put 2 structures back there. After their investigation and everything, it was denied because of water issues. And now they're wanting to put 3 houses back there and use that tiny little entrance. But our main concern is messing with the creek, wanting to raise the land so that they'll have a little more. That creek is county maintained periodically. It runs between lakes and it is for storm runoff. So my neighbor and I are very concerned about causing flooding. We have never been in a flood zone, so we do not want that. And we believe that the 1 acre of upland per septic tank was set in place for a very good reason. I'm wondering if maybe they could share a septic tank rather than put 3 of them there and involve the creek. It is also a wildlife area, as she mentioned, with quite a few things there. Also, otters use that creek. So those are my concerns.
All right, thank you very much. Be sure and sign in with the clerk. Is there anyone else who wishes to speak in opposition to this application? All right, I'm not hearing or seeing anyone. Development Services, anything further?
Nothing further.
All right, thank you. Applicant, did you have anything further you wish to add?
I wanted to say that we would be asking for 0.22 of the acre to be varied.
I'm sorry, first of all, state your name.
Oh,
first.
sorry, Amber 2. I apologize.
All right, Ms. Tu, and I'm not sure I understood what you just what you said, what you mean by
So
what you said.
basically, we're missing 0.22 acres to fulfill the acre. As far as what's needed, it would be it was 0.86. So overall, the variance would be for 0.22 acres.
All right. For that one lot, for lot 2.
Yes, ma'am.
Okay. Thank you for clarifying that. Applicant, Ms. Davidson?
Madeline Davidson, I appreciate everything Mrs. Randolph said, and we hope to be very
Ms. Davidson, speak into the microphone.
I'm sorry. We hope
Thank you.
to be very good neighbors. I believe she's incorrect about the amount of times the property has sold, because I have owned it now a year and a half, and the people who owned it prior to me, I believe, owned it for 3 years. They sold it not for any building concerns, but because they found a house already built that they preferred to purchase. The houses that we intend to build are at the opposite side of the property from the creek, so we do not intend to do anything to the creek. I'm a retired personal lines insurance agent, and we certainly understand flood insurance and flooding issues. So I believe the survey shows the area where the houses are to be built, and we're not going to mess with the creek at all. We do appreciate the creek. And there was one other issue I wanted to talk about. Now I can't think of what it is. The creek. We do not intend to raise the land at all. The height of the property is sufficient, so we're not making any of that kind of changes. It should not affect anyone else's property in terms of flooding. I believe that's it. Thank you.
All right. Thank you. All right. This will close the hearing then on variance 23-0950.
Next item is item H5, variance 230962. The applicant is Global Project Surveying. The request is a variance to lot development standards. Staff findings will be provided by Isis Brown.
Good morning, Isis Brown, Development Services, variance 23-0962. The applicant is requesting a variance to accommodate a proposed 2-lot subdivision of property zoned RSC4 per LDC section 6.0101 within the RSC4 zoning district. Required of 70 feet minimum is the lot width. The applicant is requesting a 10 feet variance, allowing a 60-foot lot width. Findings, there's currently project ID number 6610, which is under review pending this variance hearing. I am available for any questions.
All right, thank you. All right, applicant?
Good morning. Can you hear me?
Speak up, please. Cannot hear you very well.
Okay.
That's
Hello.
better.
Can you hear me now?
Yes, just make sure you speak up, and we need your name and address for the record.
All right. I am Veronica Zapata, employee of Global Project Surveying, LLC. Property address for the business is 6528 U.S. Highway 301 South, Unit 106, Riverview, Florida, 33578. I am the applicant representative to the property owner, Roniel Vasquez, for the address 12809 North Boulevard Street in Tampa. Hereby I am presenting a single variance to have the potential of dividing the property. The existing property has an existing house from the year 1959, and the property is the size total of 0.55 acres. The property owner would like to reduce the size of their lot and leave the potential for development of the remaining land for the division. Upon presentation for this proposed division, a variance to lot development standards was recommended by the zoning department, such that the existing home will be kept, but must meet the setback requirements to the proposed property line. Thus, variance 1 is that proposed lot A requests a variance of 10 feet from the required front lot width of 70 feet, resulting in a front lot width of 60 feet. The proposed lot B will not need a variance to lot development standards, such that its front lot width will measure 100 feet, and with a reduced lot width for proposed lot A, the minimum area and setbacks of both proposed lots will remain respected as per the Land Development Code. I would also like to note that there are neighboring parcels to the southeast of this property with a front lot width less than 70 feet. Finally, this variance considers that both the public and the owner of the property rights be respected. The owner will be able to divide the property and keep their existing home with less land to care for. All the while, the public rights as per the LDC requirements are to be met and respected with this land use hearing carried out. That is all. Thank you.
Okay, and just to clarify, and I'm looking at the survey, it appears, all right, there's a single-family home, and that is to remain there. Is that correct?
Yes, ma'am.
And that's on what will be the lot on the southern side of the parent parcel, correct?
Yes, that will be parcel B.
Okay. And then the lot that is being created that will have, well, doesn't have a home on it yet anyway, it appears it will have a width of roughly, well, the survey shows 71.5, but that's sort of in the middle of the lot. Is that correct?
Okay. The proposed parcel A should measure 60 feet, 60.04 to be exact, but we would like the reduction to be to 60 for record purposes of what is really the record measurement of the full lot.
Okay, so 60 feet width.
Yes, ma'am.
All right. Maybe it isn't clear on the survey, but I'm looking at it on a screen and it's kind of small, but you're asking for 10 foot, for a variance to 60 feet.
Yes.
Okay. All right, anything further?
No, not on my part. Thank you.
All right, thank you. Is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application?
Yes, ma'am. There are two of us here.
Okay, go ahead, please.
My name is Helen Hahn, 12812 North Boulevard. The property itself, the house that is there, is close to the line they want to put in there. So the houses are going to look like they're almost sitting on top of each other. They're going to be so close together. It's going to be having to go up against my neighbor's fence.
Okay, I need to stop you just 1 minute, please. Can you move your camera so I can see yeah, there you go.
Sorry.
And can you get a little closer to your microphone? We can't hear you very well.
Yes, ma'am.
All right, thank you.
They have already, over the weekend, they have been in here all weekend long with dump trucks with dirt, a backhoe digging up and putting in piping. So obviously they think they've already got the variance. We've dealt with dump trucks all weekend long over there with the noise. There's no room for them to park trucks except for on the right of way. And our street is extremely dangerous as it is, trying to get in and out of our driveways. And we don't think that this is a good idea. It's going to be an eyesore for our properties because all the houses are ranch houses with land, and this is going to be crammed little houses together this way.
All right, thank you. Is that all you have?
Yeah, that's all I have. Yes, ma'am.
All right. Is the second speaker there with you?
Yes, ma'am. Here she is.
Okay, just move the camera and speak up so we can hear you.
My name is Karen Weiss, 816 West 130th Avenue. My backyard faces right into this property. I'm a disabled person. Everything's an eyesore over there. They haven't done anything over there for years, and then all of a sudden now they're trying to spruce it up. There'll be no privacy because if they built this house, it's going to have to go up and not long, and then they'll be looking into my yard, my porch, my back family room. There'll be a water runoff, a terrible water runoff because of the building above the property, and that will come into my yard and my driveway, my porch. There already is a problem because they raised the street North Boulevard and my driveway's lower, so I get all this water runoff anyhow. So the higher they raise it. And it's, the higher they raise it, it's going to be awful. And I don't believe that this house will look anything decent over there. They'll have to go lengthwise instead of across because of the prior house that's there now, which they fixed it up very nicely. But nobody's ever had a complaint about the size of the yard before. And now, because somebody wants to do something, they're complaining about it. I really wish they wouldn't, because like I said, I'm a disabled person and it's not going to help me any. And you're going to have flooding. And I will have flooding, excuse me.
All right, thank you very much. Is there anyone, pardon me, is there anyone else here or online who wishes to speak in opposition to this application? All right, I do not hear anyone. Development Services, anything further?
Colleen Marsh, Development Services. It's just going to clarify for the record that with the RSC 6 zoning, they will still be required to meet the 7,000 square foot lot size and the applicable setbacks of 25 feet front and rear at 7.5 foot sides.
Thank you very much. Applicant, anything further?
I would like to also emphasize that we will be respecting the remaining. Oh, can you hear me?
Yes, state your name, please.
My name is Veronica Zapata.
Okay.
From Global Project Surveying. And I also would like to reemphasize that we will be respecting the remaining codes, which is the area minimum and the minimum setbacks for building in this property.
All right, thank you very much. Okay, then this will close the hearing on variance 23-0962.
This brings us to section I, special uses. The next item is I1, special use 230750. The applicant is Tillman Infrastructure. The request is a special use for a wireless communication facility and variance to site development design requirements and variance to subdivision requirements for access. Staff findings will be provided by Tim Lampkin after presentation by the applicant. Planning Commission findings will be presented by Jillian Massey.
Are you ready? Good afternoon, almost afternoon. Mary Solik, 121 South Orange Avenue, Suite 1500, Orlando, Florida. I am legal counsel for the applicant, Tillman Infrastructure. With me today is Greg Bailey, who is Director of Site Development for Tillman Infrastructure. I'm going to need every bit of those 15 minutes, so we're off to the races. Hang on. Tillman is requesting special use approval for a 155-foot monopine telecommunications tower located at 11233 McMullen Road in Riverview. The anchor tenant is AT&T Wireless, and I've put an aerial up here on the screen with the property outlined in black. The property is owned by Mr. and Mrs. Diaz. It's nearly 7 acres in size, and it's heavily wooded. The property is zoned primarily agricultural residential. The big square part of that is AR. It has split zoning on the 15-foot access strip on the south, and that is AS1, agricultural single family, and ASC1, agriculture single family conventional. Your code allows towers or wireless facilities in AR, AS1, and ASC1 up to 200 feet as a special use, provided certain locational and compatibility standards are met. And the primary one is setbacks. If the tower location, I'm going to put these up here. If the tower location is adjacent to areas that are developed residentially or zoned residentially, the minimum setback from the property lines is 100% of the tower height. And I've put a black and white site plan up here, and there is a setback chart on this plan that demonstrates that we meet the 155-foot setback from all of the property lines. And again, because the area is zoned predominantly residential or residentially used, we have to meet that setback. So we easily meet it on the large Diaz tract. These setback requirements are not insignificant. For a 155-foot setback to be met, we need to find a parcel that is at least 310 feet by 310 feet, or 2.2 acres. The development pattern in the area surrounding this proposed tower site is much smaller lots. It is no small task to find a parcel of sufficient size with a willing landlord in order to provide wireless coverage to the greater community. We were fortunate enough to find this nearly 7-acre tract where the setbacks could be met. The size of the Diaz tract also allows, along with the heavy canopy on the Diaz tract, allows for much of the view shed of the tower to be absorbed on site. The second compatibility standard is that there is a code requirement that we use a camouflage application. I'm going to come back to this one. And we are proposing a monopine, and under your code, it specifically prescribes camouflage designs that are presumed compatible. In this case, a monopine camouflage tower is what we're proposing, and it is presumed compatible under the code for AR, ASC1, and AS1 zoning district. Your staff report recognizes that we meet all setback requirements and acknowledges that the monopine is compatible based on your code. The staff report also acknowledges that we meet all landscaping, buffering, and screening requirements. The county's outside consultant, Omnicon, has also reviewed the application and determined that we meet our burden of proof of demonstrating that there are no available structures or towers within 1 mile of the existing site. He's also reviewed the information submitted by AT&T, which is the before and after coverage maps, and has confirmed AT&T's proof of need and that there will be a significant improvement in coverage in the area. And I'm going to put the Omnicon report in the record too. I'm not going to put it on the screen, but I'm going to stack it in my documents that you'll get to review later. But for the access issue that is outlined in the staff report, we would have a development services recommendation of approval. And I'm going to address the access issue in a moment, but before that, I'd like to call on Mr. Bailey to talk about the market demand for the tower and for industry standards regarding access to the tower. So I'm going to give Mr. Bailey a few minutes of time.
Good morning. Greg Bailey, Tillman Infrastructure, 299 Market Street, Saddlebrook, New Jersey. I just wanted to touch on 2 points. The first one being one of the things that towers look to do is for co-location, and for the town obviously looking to have additional carriers on the same tower. It's unusual to have multiple carriers in development at the same time. The carriers have different schedules, different budgets. They're not always working in the same area with the same needs. An older network is not building out as many new towers as a less mature network. And they're very rarely on the same schedule. But pursuant to this application, Tillman Infrastructures did reach out to the other carriers. And not only did we gain interest from 2 carriers, but Verizon and T-Mobile both submitted co-location applications, meaning that they would are ready and willing to move forward to co-locate on a tower if it was approved today. Additionally, T-Mobile provided some coverage maps similar to what AT&T had provided Although they are not on the application, they did provide these maps that would show their need for the coverage as well, and they will be submitted into the record. Also, want to talk about the traffic that the carriers, once the site is built, the traffic that the carriers have to and from the site. The traditional answer to that has always been a carrier visits a site once every 4 to 6 weeks. It is a technician in an SUV who comes to the site with a laptop, plugs his laptop in, and does some diagnostics with the site to determine whether or not it's working properly. And I'm going to stay with that answer, but I will go on record and say this: with the improving technology and moving to 4G and 5G, they have improved the equipment to be remotely monitored. Also, the site can be optimized and the antennas shifted to cover different areas remotely. So going forward, you will probably see less traffic than that 4 to 6, once every 4 to 6 weeks.
Okay. Thank you, Mr. Bailey.
Could you, Mr. Bailey, address traffic also during construction?
Sure. It will be an active construction site, so you will be having pickup trucks. There will be a crane coming to stack. There will be bulldozer backhoes to clear the area. It will be a traditional construction site. We generally look at probably 2 months for construction of the tower itself, but the crane and the bulldozing equipment is only there periodically. There will be other pickup trucks and such there on a more regular basis.
And the width of the access road, I believe it was mentioned, is 15 feet?
I believe it is 15 feet, yes.
And is that adequate for access for those equipment?
We have evaluated it and determined that, yes, we will have no problem accessing that with our equipment.
Okay. Thank you, sir.
Thank you.
Okay, so before I get into the access issue deeper, I want to just do the lay of the land. So what I've done on this document is I've outlined the Diaz property in green, the large square area here. The Diaz property continues south, and then we have the 15-foot strip that runs all the way out to McMullen Road. There's a match line up here. What's outlined in blue is also Diaz property. It's a separate tract. It's a flag lot too, and its flag extends out to McMullen Road from here. Down here is the Guerrero property, and it does not have a flag. It has no direct access to McMullen Road, and it does rely upon an easement on the Diaz tract to get out to McMullen Road.
Just a question then. With that tract, Guerrero, I believe you said?
Yes.
All right. They have a legal access easement across that yellow highlighted area, is that correct?
Yes, which has been in place since 1976.
Okay. They do not then have a legal access across the blue outline access easement to the north?
No.
That's their only access?
That's their only access. And okay. That blue line to the north is not an access easement. That is part of the ownership of the blue flag lot.
I understand. Thank you.
So before we even submitted for this application, I contacted the Hillsborough County, the Fire Marshal's office, and asked if they would approve a 15-foot access route to our tower instead of the required 20-foot wide route. Michael Hudkins in the Fire Marshal's office told me he would approve that as the tower does not generate two-way traffic, and 15-foot was sufficient to get fire apparatus to the site. At our pre-app conference, I raised the issue again, and I advised staff that I'd already talked to Mr. Hudkins in the Fire Marshal's office, and they had no issue with the 15-foot tower access width because of the lack of two-way traffic. Our written comments from our pre-app conference indicate that we needed a 20-foot access, but we could submit documentation to the contrary as approved. So I got Mr. Hudkins' sign-off in writing. This is the email from him that I'm going to put in the record, and you can read. It's part of the application, too, but you can read at your leisure. And he, again, approved the 15-foot access because the tower doesn't generate two-way traffic. We're here today because your transportation planning staff is now demanding a 30-foot access width and requiring that we request variances from two separate code sections, 60301C and 60201B5C2. I'm first going to argue that 602 doesn't apply at all. I don't know if you can see that heading. It's subdivision standards and guidelines. And then you get to the specific provisions that the staff has addressed in 5C2. I've highlighted C1 because I'll get to that in a minute. I would argue that this is not applicable. We're not subdividing property. We're not platting property. We're dealing with one easement to serve a tower site with other easements already in place. They've been in place forever. As the staff report indicates, the Diaz property is a legally existing non-conforming lot created before July 26, 1989. And the access to the Diaz parcel is not through an easement. It's through their fee ownership. It's not an easement. Access to the Guerrero property is through an easement, and it too is a legally existing non-conforming lot. Here's the deed from 1976 that created the easement that services that property. I'll put that in the record. So we're not creating any new easements to serve any new dwelling units. The section of the code that the staff has required us to seek a variance from is 5C2. If the easement serves 2 or 3 dwelling units, a minimum width of 30 feet should be required. There is no easement out there or easement proposed today that is serving 2 or 3 dwelling units. There is an easement that's been existing since 1976 that serves 1 dwelling unit, and our tower is not a dwelling unit. So even if that section 602 does apply, I would argue that C1 is the applicable section. If the easement serves 1 dwelling unit, a minimum width of 20 feet is required. So our variance would only be 5 feet and not 15.
And just, I just want to get this clear on the record. This 15-foot strip is an easement as to the Guerrero property, and it serves 1 dwelling unit on that property. Is that correct?
Yes.
And it is part of the fee ownership of the Diaz property.
Correct.
Is there a dwelling unit on that property?
There is. I'm going to jump. Let me just jump right into that. So this is 11237, which is the Guerrero property. This is 11235, which is the blue Diaz lot. And this is 11233, which is the subject property. And this is the new home that the Diazes have built on this property. You can see in this aerial that they have paved a driveway access down to the blue portion, the blue lot, and are utilizing the flag on the blue Diaz property for their access.
Are those 2 Diaz properties owned by the same individuals?
The northern one is Philip and Brianna Diaz, and the second one is Philip Diaz, and his parents live there.
All right, thank you.
This is a photo taken from Google Earth. This is that paved access road on the blue flag lot. And you see the 2 address stickers or signs on the post there for the 2 Diaz properties. So they're utilizing a different route to access their single-family home. Oh my goodness, I'm almost done. The stated purpose of the easement is solely to accommodate 2-way traffic. Put your common sense hat on. The tower doesn't generate 2-way traffic. We are not adding anything. We're not adding 2-way traffic to the de minimis level of traffic that's already that's been in place since 1976. That's the status quo. It's not moving. I'd like to go through the variance criteria, if I may. Okay.
Yes, go ahead, please. Thank you.
Practically speaking, the only user of the 15-foot strip is the Guerrero property, and adding the tower use does not change the status quo that's been there for nearly 50 years. The need for the variance arises from the unique flag lot configuration of the subject property, which is a legally existing lot. That's the first criteria. The second one is, how did the requirements of the LDC deprive you of rights? Failure to approve the variance would deprive the property owner of the ability to develop accessory uses for anything other than the single-family structure. 3, explain how it will not substantially interfere with the rights of others. The only other person affected is the Guerrero property, and they will not be affected. We're not adding two-way traffic to that easement area. Explain how it's in harmony with the code. Section 10202 and 10203 are the two sections I'm supposed to outline there. 10202 is simply the purpose of the LDRs is to make sure that you're implementing your comprehensive plan consistency. The Planning Commission has already determined that this application is consistent with the comprehensive plan. As for intent, one of the intents of the code is to foster and preserve public health and safety. The tower will allow for expansion of coverage for at least 3 carriers in an area that's currently underserved. According to the Hillsborough County Sheriff's Office, 86% of all calls, 911 calls, come in from wireless handsets. And that's the email from the Sheriff's Office. A reliable and robust wireless coverage is essential to public safety. Approval of this request also serves the general intent and purpose of Section 6.1129, your wireless facilities regulations, in that it promotes co-location and minimizes the number of towers. The variance will allow for 3 users on one tower in lieu of 3 separate towers. It's not self-imposed. The Diaz property has a unique flag lot configuration. Tower siting is driven first by the RF design of the carriers, which dictates small search areas for new locations that fit in the carrier's design network. Then we have the local land use regulations that direct us to certain size tracts to meet setback requirements and locational criteria. And this heavy regulation of cell tower placement eliminates most properties in a residentially developed area. Justice will be done. We contend that the consideration of this the criteria requires that you balance the public benefit to the community of improved coverage to the underserved area and the benefit to the community of increased competition in the larger community for wireless provider choices, and the enhanced public safety with better E91 service with the de minimis risk of two-way traffic on a 15-foot strip of land. Based on the information I've submitted, we believe we've met our burden of proof and the variance is due to be granted. I'll stand for questions and I'd like to rebut citizen commentary.
All right, thank you. I have no further questions for you.
Okay. Let me do my housekeeping. Oh, I missed one.
Be sure and sign in if you haven't done so already. Thank you. All right, development services.
Hello, Tim Lampkin, Development Services, presenting case 23-750. Pursuant to, I'm not going to repeat everything that the applicant put into the record in order to eliminate some duplication. But pursuant to Land Development Code, Section 6.11.29, the request is for a special use permit for a proposed wireless communications facility with a 155-foot high antenna tower with a tree-type camouflage that will be located at 11233 McMullen Road. The site is located within the urban service area. Nearby uses include single-family residential, planned development, mobile homes, mobile home parks, single-family residential, and agricultural. As the applicant stated, documentation indicating the need for a facility at the height of 155 feet for the desired coverage area was reviewed and by an outside expert. And pursuant to Land Development Section 6.11.29.g, the letter of intent committing the antenna tower for shared co-location has also been submitted. Notice to other potential users was sent back in June. Staff's findings. The proposed tower compound is located on the northwestern portion of the subject property. The proposed communications facility meets land development code requirements, and the applicant has not sought any waivers to the regulations contained in Land Development Section 6.11.29. The applicant does not request any variances to the Land Development Code's Part 6.06.00, landscape and buffering, as the site is heavily wooded, and the applicant proposes to allow the use of existing vegetation in lieu of required screening pursuant to LDC Section 6.06.06.C.12, which will allow them to not clear cut the land and provide a minimum of 6-foot tall opaque fence to visually also screen the compound on all sides, which I believe has been reflected in the applicant's proposed conditions of approval, which they would have submitted. Planning Commission staff did find the proposed special use is consistent with the goals, objectives, and policies of the comp plan that was before Transportation submitted their analysis. There are two variances. Section 6.11.01.c, minimum access width requires a two-way driveway access, and section 6.02.01.b.5.c2 requires an easement 30 feet in width serving 2 or more dwellings. Transportation staff is requesting the 6.03.01c, then you refer to cross-reference what the width would be for the two-way driveway, which is why both of the easements are included. And it's to allow the 15-foot wide access easement for two-way driveway. Transportation staff indicated objection to the proposed communication facility pursuant to the 15-foot wide drive. Pursuant to Land Development Section 6.02.01.b.5.c.2, Transportation staff finds that the width serving 2 or 3 homes shall be a minimum of 30 feet. Given that the access does not meet minimum standards to accommodate 2 homes, staff cannot support the addition of trips, which could create safety and/or operational problems when traffic is unable to pass. As such, Transportation staff is unable to support the request, while staff finds the proposed wireless communication facility is in compliance with LDC Section 6.11.29 and finds the location to be compatible with surrounding land uses. Given Transportation staff objections to the substandard access width and variance request, staff cannot find the proposed communication facility is supportable, and based upon this, staff finds the proposed communication facility not supportable to Transportation's objections and findings that the substandard access is not adequate. And Transportation staff is on the line remotely. If you have any questions about the access, if you had any other questions, I am here for questions.
Yes, if you don't mind, you did cover this, so if you would back up to those sections of the code and just state those things again. The sections of the code.
For the variances?
Yes, for the variances.
Okay, so the first.
And slowly, please, because there's a lot of dots and dashes in those. Thank you.
There are, yes. Mm-hmm. So the first one is section 6.03.01C, and this is when an easement is used for access, a minimum width of a two-way driveway is required. As that width is not specifically dictated, then staff is referring to Land Development Code 6.02.01.b.5.c.2, which would be the second variance request, which requires section 6.02.01.b.5.c.2 requires a 30-foot wide access easement width to serve 2 to 3 dwellings, and there is a 15-foot access easement existing.
And the 15-foot width, as we heard from the applicant, serves the Guerrera lot as an easement?
So I don't have the names memorized of all the property owners, but watching the applicant, it appears that that is the one that is located on the legal non-conforming lot that's been there prior to July 26, 1989.
Right.
So you have that 15-foot wide strip. There's a lot immediately to the right. North of that, there's another lot. Is that the lot you're speaking to?
I'm speaking,
Hold on, I can bring up.
I don't know the directions, but it might be, hold on a second, let me pull up the site plan.
Let me do this. I actually have something on the overhead right now.
Thank you.
So I think, are you speaking about this property? So here's the 15-foot wide property, flag lot, and then which is also then an easement to
That
this property.
Right. So
That's my understanding.
So as to that property, the 15-foot wide drive is an easement and it serves that property. And there's a single-family home on that property. Is that correct?
That is correct. That's my understanding.
Okay. And then as to the subject property, where the proposed cell tower will go, or the proposed communications facility, that 15-foot land there belongs to that lot, so it is not an easement as to that lot. Is that correct?
That is absolutely correct.
Okay. And there is a single-family home on that lot?
Correct, approximately here.
Okay. So the easement serves one lot where there's a single-family home, and where is the second lot that transportation says there's a single-family home being served by an easement?
So I'm going to let transportation answer that for you.
Thank you.
Mm-hmm.
Good afternoon. For the record, James Ratliff, Development Services Transportation Review Section. So the two homes that are being served by the area which underlies the easement is the home that is constructed on the subject parcel. The applicant provided testimony that home is taking access from the 15-foot flag that's serving the other Diaz family member. Again, I would just point out that access is being taken illegally, that the other adjacent Diaz parcel it's also a legal non-conforming lot. It can only serve that one legal non-conforming lot. It cannot serve two dwelling units. And so the flag for this parcel is intended to, and that's indeed how it was permitted, that home was to be served by the flag lot for the subject site. There's that additional Guerrero easement, which is the second home that's being served within that 15-foot area. And then, of course, the applicant's proposing to add the tower as well to the mix. So those are the two homes that we were referencing.
Okay. So just to be clear then, transportation is referencing the Guerrero property, which is being served by the 15-foot wide driveway access, and that driveway access is an easement as to the Guerrero property. Is that correct?
Correct.
Okay. And then the subject property where the proposed cell tower is to go, that 15-foot drive is part of that parcel, so it's not an easement as to that parcel. Is that correct?
That is correct.
Okay.
And then there's an additional easement that the applicant is proposing to serve the cell tower site, just to provide legal access to the area of the site that's being served by the cell tower. So that would be an additional overlapping easement on top of that.
I'm sorry, say that again. Are you talking about the 15-foot driveway area that belongs to the subject property? You're talking about that area, is that correct?
Correct, yes. My understanding is the applicant is proposing an easement that's going to provide access from McMullen to the cell tower portion of the folio through the subject folio. So essentially there will be, on that 15-foot flag, there's legal access for the subject parcel, the Guerrero parcel, and then of course the cell tower will be served by that flag as well. And there will be at least 2 easements within that, within various portions of that area. Of course, the Guerrero, I'm not sure how far the Guerrero easement goes, but at least for some portion of that flag, it's going to be served by, it's going to serve as access for those 2 homes plus the, plus the tower is what they're proposing.
So there will be an easement on the 15-foot drive area to serve the cell tower site. There will be an easement as granted as to the tenants, I guess, of that cell tower site. But that's not a single-family home. That's just to the cell tower site.
Correct. Yes, we think what's, again, understand what's important is not how many homes the legal document says is that particular legal document is serving. What's driving the need for the width is how many things are actually driving in and out of being served by the area. And so that's where the code says, if 2 or 3 homes are being served via an easement or the area, the dirt that underlies that easement essentially, then that's where the 30-foot width is triggered. If it's a flag lot for a single home, it would be 20. And of course, this is a 15-foot flag, which is perfectly fine because it's legal non-conforming. So 1 home can develop on the 15, even though it doesn't meet minimum standards for a single home today. It's the issue comes into play with the intensification to add anything else.
I see, but the land development code does specifically refer to dwelling units, the number of dwelling units being served by an easement. Isn't that correct?
It says if the easement serves 2 or 3 dwelling units, correct. Then the easement width would be 30 feet. And then when you look at the other, the site development portion of the code, which is the one being triggered by development of the cell tower, it says that you need the minimum width of a driveway, or the easement needs to be the minimum width of a driveway that accommodates 2-way access, is what the land development code says. And so, that's where we look to say, okay, well, if, for a piece of dirt that's serving 2 homes, the minimum width of that access of a 2-way access way is 30 feet. And the cell phone tower, it's essentially what is the worst case scenario of that area that's being accessed, and it's the 30-foot requirement.
Okay. All right. Thank you, Mr. Ratliff.
Thank you.
Planning Commission.
Good afternoon, Madam Hearing Officer. My name is Jillian Massey with Planning Commission staff. The subject site is located in the Residential 4 Future Land Use Designation. It's in the urban service area and within the limits of the Riverview and South Shore area-wide systems community plans. The proposed special use is compatible with the character of the surrounding area and meets the intent of Policy 1.4 of the Future Land Use Element. The proposed 150-foot monopine wireless communication tower will be in an area that's heavily wooded, and the camouflage design will be reflective of the existing tree canopy in the immediate area. The request does not include any variations to the required setbacks or buffers. The area surrounding the tower will be fenced, so the compound will be screened from all sides. The design is sensitive to the surrounding residential uses and preserves the mature trees. Therefore, the request meets the intent of the neighborhood protection policy direction under Future Land Use Element Objective 16 and Future Land Use Element Policies 16.1, 16.2, and 16.3. The proposed special use also meets the intent of Future Land Use Element Objective 46 and Policies 46.1 and 46.2 that require telecommunication towers and facilities to be in areas that have compatible land uses and adhere to all local, state, and federal laws. The applicant is requesting a variance to allow a minimum access width of 15 feet. However, at the time of filing this report, there were no transportation comments filed into optics. So that was not taken into consideration during this analysis. The proposed special use meets the intent of the Riverview Community Plan and South Shore Area-Wide Systems Plan. The proposed monopine tower will provide an appropriate and compatible buffers and transitions to the existing adjacent land uses, and the proposal will implement technologically advanced infrastructure. And based on these considerations, Planning Commission staff finds that the proposed special use is consistent with the unincorporated Hillsborough County Comprehensive Plan, subject to the conditions proposed by the Development Services Department. Thank you.
Thank you. All right, is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? Please come forward. Wait until you get to the microphone to speak, please. How many speakers do we have, first of all? Are there 4? Okay, so 3-4 minutes apiece. The 15 minutes is divided among you, allotted among you. Okay.
Good afternoon, everyone. My name is Nancy Berry. I'm at 11351 McMullen Road, Riverview. First of all, the sign for the usage was on the wrong location. It's about 5 different places over. And my thing is, I've been a resident now there in the area since '95. That's 28 years. It's really residential area. It's going to devalue our property. It's going to be an eyesore. I don't care how much stuff you put on it. I also worry about my health, because we don't know what that cell phone tower can do. All the properties in the area are around an acre or so. So now you've got this one little patch, so we're gonna destroy everything. We used to have, I have cell phone too, T-Mobile. I don't have an issue using that. These big companies come in and they wanna take a nice area that's been with wildlife and everything there, and they wanna destroy it. When we first moved in that area, there was a lot of wildlife. Whippoorwills, I don't hear them anymore. We had bunnies going around, we had foxes, we had sandhill cranes. We have a hawk, and he's got a nest back in that area. So what do we just keep cutting down the trees and ruining all our natural wildlife? There's so many other areas they can put this tower in. It's going to be a disruption for the whole area. There are going to be things moving in and out, and I totally don't agree with any of this. There's also a flower called the golden aster, and that's an endangered species. They're not going to worry about any of that when they excavate. They're not going to worry about animals that live in the trees, nothing. Why do we keep destroying stuff? We had electric lines put in, so we removed a lot of trees too in front of our house. Why? Why can't we let something be natural and just enjoy it? Just because they found a little 7-acre property, oh, we could put a tower in there. And so our beautiful area is going to become really, really an eyesore and devalue our properties. And nobody realizes it till it's going to actually be there. These are big companies. They can go find land somewhere else. They don't need to destroy ours. Thank you.
Next speaker, please. Thank you.
I'm Joel Sonical, 11218 Creek Haven Drive in Riverview. I'm here today representing the majority of residents in the Creekview subdivision of 128 homes. Over 135 people have signed the online petition, and many other residential property owners in close proximity that oppose this unnecessary special use request. We firmly object to this request, which holds the potential of exposing our residential community to a 160-foot communications tower and its negative impact on life safety, health, property value, and overall aesthetics of our community. We are hereby requesting decision makers deny this applicant's request to ignore access requirements for this lot, which stands to expose residents and their properties to a serious life safety risk. Specifically, Hillsborough County has access requirements, including a 20-foot access requirement for a single-family residence and a 30-foot access requirement for those greater. The lot in question only has 15 feet of access and clearly does not meet the standards set forth for a single-family residence, even without the near 12-story monstrosity of a tower they are proposing. Furthermore, the 20-foot requirement is listed as an absolute minimum by the National Fire Protection Association, or NFPA, stating the 20-foot width allows for two-way vehicle traffic and for one fire apparatus vehicle to pass, while another is working at a fire hydrant or conducting aerial operations. This is stated as a minimum and does not account for the unique firefighting obstructions found on this parcel. As a reminder, this is a heavily wooded area according to the survey, and these towers are basically lightning rods. This is coupled with highly restrictive access, no lighting, makeshift gravel road incapable of managing the weight of these massive fire trucks. Don't even mention rainy season. This tower is also projected to be located at the back of a parcel behind an existing residential home with inadequate access, making this proposal a recipe for disaster. So what is driving a multi-billion-dollar company and one single resident's desire to add another tower in addition to the over 80 towers that already exist in a 3-mile radius of 11233 McMullen Road? Good question. AT&T actually provided a letter in this application stating that the nearest tower, which can accommodate this very same equipment, is less than 1.5 miles away, which brings into question why this company is not sharing existing towers as directed by the Federal Communications Commission. The FCC also provides maps showing substantial coverage in this very same area. Research also shows towers of this magnitude can communicate up to 45 miles. When it comes to health, we are also justifiably concerned. Everyone has their own opinion on the overall impact on these unsightly towers create for your health. However, the consistent theme highlighted by numerous researchers includes risks of radio frequency sickness, changes in biochemical parameters, and cancer. For those who are not already aware, research also shows property values stand to lose around 20% depending upon your home's distance from these eyesores. There is also less desire to purchase or rent these very same homes, which equals lost revenue for the county. Coupled with the loss of property value is the unnatural punch in the eye from this imposing 160-foot tower leaning over these properties. Set the picture. We have a single-family home, which is about 15 feet high. It would take over 10 of these homes stacked up on each other to reach this height. To say this tower is consistent with county planning, who defines compatibility as located near or adjacent to each other in harmony, is simply not true, especially considering the City Council Planning Commission stated the very same elements of height, scale, mass, and bulk of structures affect compatibility. The property adjacent to this lot went up for sale following the announcement of this special use request, which is likely not a coincidence, an example of what we present here. In summary, the residential community does not support the special use request for a 160-foot communications tower and its negative impact on life safety, health, property value, and the overall aesthetics of our community. Thank you for your time in enforcing land use that does not compromise the health and wellness of its residents.
Thank you. All right, next speaker, please.
Hello, my name's Pamela Kitts. I live at 11022 Charmwood Drive, Riverview. That's in Forest Glen. That is directly in the same community that we're talking about. Our community is very special. It's small. We all appreciate the trees, the wildlife, the nature preserve, the wetlands that are there. It's our home. We live there. This is homes that we've worked hard for, we come home to, we raise children there, we have grandchildren there. It's not as easy as you think to just raise something like that that could potentially harm all of us. This is a big decision, and I'm hoping that you will understand our side. There are health concerns. There are studies that show that they may potentially cause cancer. Some suggest that really you should be a 10-mile radius away from cell phone towers. This tower will sit directly over our private homes and our neighborhoods. It will be 150 feet tall, 55 feet tall, potentially could go another 25 feet should they choose. It will umbrella over us. There are no trees in our area that are 155 foot tall. This is a very small area. It does lower our property values as well. Studies show that 25% lower, people see that it might as well be a sinkhole because they're scared of them. We all work hard for our homes. It's all that we have. It's our safe haven. We want to be able to come home to our beautiful community. There's no need for another cell tower.
You can Google yourself and see that there are 24 registered cell phone towers in our direct
Riverview area. And it's said that there are 80 within a 3-mile radius of us. I can look out my windows and count at least 6. And it's arguable that too many cell towers is what causes the poor reception, not adding more. I ask that you would take into consideration that it's not right to demand a potentially hazardous structure as big as this one would be to tower over our communities. It will tower over at least 2 schools as well, Riverview High School, and then there's an elementary school there as well. Our family, health, and safety and personal properties should take priority over cell phones. I ask that you please find an area, another area for such a large, harmful, unsightly structure as this to be placed. Thank you.
Thank you, ma'am. Next speaker, please.
Hi, good morning. My name is Dorian Ferrante, and I'm a resident at 11150 Creek Haven Drive, and that's in Riverview. First, I wanted to thank this committee for giving us the opportunity to discuss the rezoning proposal for the cell tower. You know, in the interest of time, I think there's 4 main points that I really want to get across that I think is needed to prevent this proposal from moving forward. Just as some background, you know, I've lived in the Creekview neighborhood now for 13 years. My wife and I are currently raising our children in this neighborhood, and we definitely have concerns with the construction of this cell phone tower. If we had decided to move into this home and this tower was pre-existing, well, that's one thing, right? But putting this up after residents have lived there for so many years, you've heard from previous testimonies, people have been there over 20-plus years living in this area. There are some concerns. I mean, we're talking about a 150-foot structure. And just listening to some of the testimony, I think I have to go back and check my definition of the word camouflage, because the tree line right now, as it currently exists, is around 60 feet tall. This is going to be 150 feet. That's 90 feet above the existing tree line, which is going to be an absolute eyesore for all the residents that are there. In terms of the environmental impact, I'd like to talk about that, because right now we currently live on a preserve. In our backyard, there is a ton of wildlife, bobcats, coyotes, snakes. We have a ton of birds, owls, falcons, turkey vultures, etc. There have been studies that have shown from the from the International Journal of Avian and Wildlife Biology that birds tend to migrate away from cell phone towers because of the damage that is being done to their reproductive systems, and also the populations of these species decrease over time. So that would be one thing that I'd like to see more of, is the environmental impact analysis that's being done by Tillman Infrastructure. Second, of course, there's the financial concern, right? I mean, any resident of this community, it's going to be difficult in the future for selling this property, selling any property, or leasing it out. You know, I don't see having a cell phone tower in someone's backyard on every buyer's wish list, right? Most people are concerned with the property, the internal structure, but a 150-foot cell phone tower is definitely going to negatively impact us. Third, of course, are the health concerns, and as a parent, I can tell you I have lots of health concerns. Now, I understand that the radio frequency exposure can't be addressed at the local level, and that's something that's done at the federal level by the FCC. But when you read and you do some research on these cell phone towers, their negative impacts are quite significant. We're talking headaches, sleepless nights, fatigue. You're also talking about, obviously, brain tumors and cancers. So for any parent and any child that lives near these things, this is a major concern for us. And then last but not least, I think the community has spoken here. I mean, we have over 130 people that have signed this petition that are against the building of this cell phone tower. There are plenty of areas in Riverview, up and down 301, where cell phone towers currently exist. I can tell you as a T-Mobile customer, I have no problems with reception. So I think what we'd like today is for this committee, based on all the information that's been presented, is to stop this initiative from moving forward. And we ask that Tillman Infrastructure find another parcel of land to build their cell phone tower. So thank you today for your time and consideration.
Yes, sir, thank you. All right, County Development Services, anything further?
Nothing further.
All right, thank you.
Thank you. I've heard the citizen commentary today, and I've reviewed the commentary that's been submitted online, and there are a number of common themes, and I'm just going to address them as common themes. First is that the tower doesn't belong in a residential community. That's simply just not supported by your code. Your code allows towers in every single zoning category that you have, except for your airport zoning categories. And you have compatibility and locational requirements that address compatibility with off-site uses, and we've met all of those. Your code contains a provision about you require camouflage applications in almost every category, and in this particular zoning category, the monopine is presumed compatible under the code. So we've met our burden of proof. We meet the code. You didn't hear any evidence today from the neighbors, any competent substantial evidence to rebut that presumption that the monopine tower is compatible with the area. Your code doesn't regulate property values. That's really not something that you're supposed to consider. And of course, you know that the Telecommunications Act prevents local governments from evaluating or denying tower applications based on their health effects or their environmental effects. We still have to go through site plan review on this particular tower. That's where any impacts to wetlands or gopher tortoises or anything else that may be out there will be addressed. This is the entitlements phase of our process. So the site plan will take care of all of those types of on-the-ground environmental impacts. We will be, there was an issue or a question raised about whether the road will be sufficient to support the construction and the fire department. We will be required to build stabilized access sufficient to support our own construction equipment and the fire department equipment. That will be part of our site plan approval. And I just want to, you did really address the code. I want to go back. I didn't get a chance to talk about the 60201 requirement. Now I can't find my notes. You really hit it on the head. The easement access is only being provided by one user, and that is the Guerrero property. And the staff is borrowing the language in 60203.5C2 for 2 or 3 dwelling units, even though that says easements, to require 30-foot here. I don't agree with any of that, but at the end of the day, the code shouldn't, I read the code as not requiring any more than 20-foot access for a structure that's not a dwelling, and that is only to provide two-way traffic. We're not developing two-way traffic. It's one-way traffic on our site. Our 15-foot is sufficient. Let me see if I've anything else. And I think that's it. We would ask for your approval of the variances and of the application itself.
All right, thank you very much. That concludes the hearing on special use 23-0750. We're going to take a break. We'll reconvene at in about 10 minutes. We'll just say 10 minutes. Thank you. All right. All right, we're ready to reconvene. This is the October 23, 2023 Land Use Hearing Officer meeting. I believe we're going to go back to case variance 23-0949. It's my understanding the applicant is not present and not able to be here today due to travel. So we're going to entertain a continuance. This case will have to be continued to the December Land Use Hearing Officer meeting. Do we have a date?
December 19th.
December 19th. All right. We'll just ask the public, is there anyone present, anyone here or online who wishes to speak for or against the continuance of this matter? Not hearing the case at all, but we're just asking for public comment only as to the continuance. Yes. If you wish to speak to the continuance, please come forward. We need your name and address first.
Hi, I'm Lisa Cheryl Tingen, and I reside at 8402 Old Country Road. With regards to the continuance, we've been patiently waiting. This would be the third attempt at this variance request. The first one occurred in 2022, and it was denied by staff. The second attempt was made prematurely on behalf of the applicant, and they were advised to withdraw. And now here we are today, again, with regards to this variance for a maximum wall height. Myself, my neighbors, we are in opposition. Nothing has changed in this application, and we just feel like we've all done our part. We took our time, we registered to speak, we did our opposition letters, we had the courtesy and respect for staff and for everyone involved. So the fact that the applicant can't be here today really doesn't seem fair upon the residents in Hillsborough County, even as a taxpayer, that this is an initiative that you've brought. This is a hardship that we can't still even determine that it's a hardship. So I'm against the continuance.
All right, thank you. Be sure and sign in with the clerk. Is there anyone else here who wishes to speak? Yes, sir, please come forward. I need your name and address for the record.
John Whitehead.
Yes, sir. And your address, please.
11339 Sandpiper Avenue, Brooksville, Florida.
Thank you. Right.
This is not the third time. The second time was, there wasn't an understanding on our behalf of that you have to wait 1 year. So that was a technical issue or just lack of understanding on our part.
All right, was that a different case then? That was a different variance case. Staff, is this the first time this case has been heard?
Yes, this particular case, yes.
Okay. So, sir, I think you mean the applicant had applied in a previous application. Is that correct?
Yes.
Okay.
And we were told that due to, there's a rule or statute that you have to wait 1 year.
Okay.
That's what that was.
Okay.
So we waited the year and then put it through.
So are you speaking in support of the continuance?
I am.
Okay, and what is the basis for the request for the continuance?
The basis was the applicant had a personal emergency, had to fly to Chicago. I'm not sure exactly the details of it. I got caught off guard myself, to be honest, but I was informed that it was an emergency, and he's going to be back in touch with me ASAP, but I just don't know when that's going to be. Or the extent of the circumstance.
Okay, thank you. Is there anyone else here to speak only as to the continuance of this case? All right, I'm not hearing anyone. All right, so based on the applicant having an emergency and not being able to be present today, I'm going to grant a continuance of this case. It will be continued to the December 19th, 2023 Land Use Hearing Officer meeting. And we're ready for the next case, I believe.
Next item is item I2, special use 230982. The applicant is George F. Cordova. The request is a special use 4 COP RX alcoholic beverage permit with separation waivers. Staff findings will be provided by Camille Krakta.
All right, is the applicant present?
Hello?
Yes, go ahead.
Hi, yes, this is for 230982. My name is Dixie Liberty. My client, I live at 200 Adams Avenue, Hopkinsville, Kentucky. I am here on behalf of my client. He's requesting a 4 COP RX. His address is 1509 East Fletcher Avenue, Suites 111, 112, and 1113. This is going to be a restaurant. He is going to be selling beer, wine, and liquor. The square footage is 3342 square feet. There is no outdoor seating. We're asking for one waiver within 150 feet for residential. This belongs, the property that's in question, it belongs to Hillsborough County Real Estate Department. And the property has a retention pond on it. It's a retention area. And I saw in the staff notes that the staff report shows that it's unlikely to be sold and developed for a residential purpose. The hours of operation for this establishment, this restaurant, is Monday through Friday, 8 a.m. to 10 p.m., Saturday, 8 a.m. to 12 midnight, and Sunday, 8 a.m. to 10 p.m. And I understand that there's going to be no alcohol sold on Sundays until 11. That they are going to have 49-51%. 49% is going to be for alcohol and 51% is going to be for food. They have to meet that requirement by the beverage department also to have a liquor license for a restaurant.
Thank you, Ms. Liberty. Is that all?
And yes, ma'am, do you have any questions for me?
I don't believe I do. Thank you.
I'm sorry. One other question. I mean, it's not a question. It's to ask. Is there any way that you can make your decision within the 15 working days? There was an issue with the county of getting back to have an issue resolved that they found for the real estate residential development. They notified me, like I believe it was the last day or the day before the 30 working days, because we were not going to go to a hearing.
I'm not sure I understand that question. The final decision is due on these cases November 14th.
Right. I already had it put in as a no hearing because there was nothing out there. And I had 30 working days per the county. And they came to me like basically on the last day of that decision. And that's when we had to set schedule for the hearing. I had to fast track it.
I can clarify a little bit for the record. There's two types of alcoholic beverage permit applications, one that's administrative and then the hearing process. And this was originally submitted as an administrative permit, which it has a 30 business day review. And it was identified that there was the residentially zoned property within 150 feet. And that's what then triggered this review.
Okay. All right. So, Ms. Liberty, what is your question? I guess I understand how that came about. You're asking if we can get it in earlier. Is that what you're asking?
Yes, ma'am, because my client is paying rent and it's, he's got 3 units there. So we're just trying to find out if we can get this answered for him soon within the 15 working days.
Okay. I cannot guarantee that for you. I'm sorry. I I can't tell you that I can get it
It's
in
okay.
earlier than the 15 working days.
I was just told to ask, that's all.
Understand. Thank you.
Thank you.
All right. All right. Is there, well, no, Development Services. Thank you. We'll hear from Development Services now.
Good afternoon, Camille Crockett, Development Services for SUAB 23982. The applicant is requesting a 4 COP-RX AB permit for a proposed restaurant at 1509 East Fletcher Avenue in a recently constructed Fletcher Shops 2 commercial building and is currently zoned CG. The total footprint will be 3,342 square feet. No outdoor area is proposed. The applicant is requesting a waiver from LDC Section 611.11 for a waiver of the 150-foot distance requirements to residentially zoned property. They are requesting approximately 37 feet from the residentially zoned property to the east, and it's zoned RSC 6 at this time. So they're requesting a 113-foot waiver. Staff findings: the parcel has been owned. It was purchased through, well, it was done through a taking by the county in approximately 1973 to 1975. It remains undeveloped, is currently used as retention area as the applicant stated. The section that is adjacent to the proposed wet zone is a small access strip about 60 feet wide, which wouldn't meet development standards for zoned property residential in that area. And Hillsborough County did administer a driveway permit for access to the shopping center there. So it is unlikely that anything would be developed in the area because it doesn't meet the lot width requirements. So with the above stated considerations, staff finds the proposed 4 COP-RX alcoholic beverage permit to be approvable, and it's based on the wet zone survey received on September 6, 2023. That reflects a total footprint of 3,342 square feet. And that concludes my presentation.
No questions. Thank you very much. All right. Is there anyone here or online who wishes to speak in support of this application? All right. Not hearing anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right. Do not hear anyone. Development Services, anything further?
Nothing further, thank you.
Okay. Applicant, did you have anything further?
No, ma'am.
All right, thank you very much.
Thank you,
This
ma'am.
will close the hearing on special use 23-0982.
Next item is item I3, special use 230996. The applicant is Venkata Gudipati. The request is a special use 3PS alcoholic beverage permit with separation waivers. Staff findings will be provided by Jared Fullen.
Hi, madam. Good morning. This is Venkata Gudipati, and I live in 12194 Hazelmore Court, Jacksonville, Florida, 32258. I am requesting the 3PS special use permit for 5253 Elric Road, Tampa, Florida.
All right, and what is the use? Just describe what you're requesting, please. And
It's a special use, okay, special use 3PS permit. It's a package store.
all right, and you're requesting a separation waiver?
Yeah, separation waiver for community use and the residential zoned property, 250 feet.
All right, and are there what are the circumstances upon which the waiver should be granted? What are there?
The one is, okay, they have the church. It is on the wet zone survey says 50 feet, but the Google Maps says, okay, it is almost, okay, 528 feet when you drive or walk, and it has fenced with the wooden fence. The other church is across the road, that is survey says 317 feet, but it is, if you go with the Google map and by driving or walking, it is 1055 feet. Then the other one is, okay, it has a residential zone, and they built the church from past since 2000. It's the same as the first one, basically, 14913.
Okay. All right. Anything else you wish to add?
No, madam. Thank you.
All right, thank you. Be sure and sign in with the clerk here, please. All right, Development Services.
Hello, Jared Fallon with Development Services. This is a request to acquire a waiver to a distance separation requirement for a 3PS alcoholic beverage permit. This wet zoning is sought for a proposed retail liquor store within a strip center located at 5253 Elridge Road that will comprise of a footprint of 3,020 square feet of indoor area. The zoning of the property is CN, which is commercial neighborhood, which allows the proposed use. For 3PS permits, sites must be at least, or community sites must be at least 500 feet from community uses and 250 feet from residential zone property. Based on the submitted survey, the proposed site is within 500 feet of 2 community uses and within 1 residential property. The 2 community uses are nearby churches, Northwest Community Church and Messiah Lutheran Church. And the residential property is the same property that has the Northwest Community Church, which lies adjacent to the north. The Messiah Lutheran Church is located 317 feet to the west across Hutchinson Road, which is classified as a major roadway. The church structure itself is set back approximately 180 feet from the right-of-way, making the walking distance about 380 feet. However, the furthest crosswalk is about 500 feet to the south, which further separates the uses. Northwest Community Church is located 50 feet north and is zoned RSC 6. Between the properties, there is a 6-foot solid wood fence and some vegetation. Approximate walking distance to this church structure is about 800 feet, and it is 380 feet to the property entrance. As for staff's analysis, the walking distances to each use is an adequate distance to where we believe there will not be negatively impacted. Additionally, with the physical barriers such as Hutchinson Road and the 6-foot fence, we do not see a significant connection to these uses. For these reasons, we find the proposed wet zoning to pose no significant impacts to the surrounding land uses and find the proposed permit to be approvable. Happy to answer any questions.
All right, no questions for you. Thank you.
Thank you.
All right, is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? Do not hear anyone. Development Services, anything further?
Yes, I just noticed a typo in the report on page 1. I just want to point it out. For the distance separation requirements, where it says complies with the requirement, those are actually reversed. It does not comply with the
I see.
To distances certain community uses in residentially zoned property, and does comply with the no more than 3 within 1,000 feet.
Okay. Will Development Services make those corrections and put a revised?
Yes, we can do that for you.
Thank you. That would be helpful. Thank you. All right. Applicant, anything further? All right. Applicant says no. Then this will close the hearing on Special Use 23-0996.
Last item on the agenda today is item I-4, Special Use 23-1027. The applicant is Central Florida Petroleum Distributors. The request is a special use 2 APS alcoholic beverage permit with separation waivers. Staff findings will be provided by Isis Brown.
Good afternoon, Ms. Hatley. Patricia Ortiz. My address is 2810 North Central Avenue, Tampa, 33602. And I am representing Central Florida Petroleum Distributors in this request for a 2 APS, that would be a beer and wine license for off-site consumption in conjunction with a gas station The property is located at the northwest corner of 56th Street and Sly Avenue. This property has been used as a gas station since at least 1985. The first AB special use permit or wet zoning, I think it was called back then, was issued in 1984, and that was a beer-only license. In 2006, the then property owner came before this board and asked for a 2 APS to allow the sale of wine. We're here before you today because the site has been redeveloped with a larger store, which changed the configuration of the wet zoning. So we're asking for a new 2 APS, and that would, of course, restrict sales, alcohol sales to beer and wine consumption off-site. Our challenge is that the site is located within 500 feet of King High School and within 500 feet of the, I want to make sure I get this right, Living Faith Baptist Church. The school is separated from the site by 56th Street, which is a 6-lane arterial roadway. It creates a significant buffer and increases the actual distance to be traveled to somewhere around 500 feet, a little over maybe. The nearest school building is located more than 500 feet from the service convenience store. Also, there's another alcohol sales establishment closer to the school, and that would be located at the northeast corner of the intersection. The church is located also within 500 feet, but it's separated from Sly Avenue, and a reasonable person walking or traveling between the two sites would have to, deal with the 4-lane roadway there, probably cross the street at the crosswalk, we would hope anyway, and that would make the distance of separation equivalent to 500 feet, give or take. We did receive a letter of no objection from the church, which I'll submit into the record today. And that kind of concludes my presentation. If you have any questions, I'd be happy to answer.
All right, no questions for you. Thank you.
Sounds good. Thank you.
Okay. Development Services.
Oh, yes. Good afternoon. Isis Brown, Development Services. Special use AB permit 231027. Property zoned CG and CI, address 6820 North 56th Street, Tampa, Florida. As Ms. Ortiz said, I'm not going to repeat everything that she said, but pursuant to Land Development Code 6.11.11, the request for the distance separation for two APS alcoholic beverage permits for the sale of wine and beer in containers only, packages consumed on licensed premises packages is 500 feet. The property in question is located within 500 feet of the church to the northwest, and then the King's High School is to the southeast. Separated by 56th Avenue, which is the 6-lane road. The applicant is requesting a separation separation waiver from the school, King's High School, resulting in a 310-foot separation, and from the Living Faith Baptist Church of resulting in 180 feet separation. Based on the above considerations and discussions, staff finds the wet zone does not pose significant impacts on the surrounding land uses, and the necessity for specific distance requirements is negated. They will not be rescinding special use permit -0506. Staff finds the proposed SUAB 231027 alcoholic beverage permit is approvable. Approval is based upon the wet zone survey reflecting the total wet zoning footprint of 4,793 square feet as shown on the survey received September 19th, 2023. I am available for any questions.
Okay, just to clarify then, if this one is approved, this request, the prior approval does not get rescinded?
Not in this case.
In this case, the legal description does not actually overlap, so it would not require it to be rescinded. The applicant could voluntarily rescind, but where we typically rescind one permit for the issuance of another one, because one is permitted within that legal description, we wouldn't need to in this case because the legal descriptions do not overlap.
Okay. All right, thank you for clarifying that. Okay. All right, is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, do not hear anyone. Development Services, anything further?
Nothing further.
Okay, and applicant, anything further?
Nothing further. I just wanted to let you know I'll work with staff to figure out how to rescind that application or that outstanding wet zoning, because I think that might create an issue of number of wet zonings in a specific area. Anyway, I'll work with Colleen to rescind that if that is in the best interest.
All right, I'll note that for the record.
Okay.
All right. Thank you. This closes the hearing on Special Use 23-1027, and that will conclude the Land Use Hearing Officer meeting for today.